Well, good morning to all of you. I can't remember a day when I've had so many people saying good morning to me.
It's a
On
beautiful
behalf
morning.
of the State Bar of Georgia Alternative Dispute Resolution Section, I want to welcome each of you to our program in celebration of International Conflict Resolution Day. My name is Joyce Clemmer. I'm an arbitrator and a mediator with JAMS, and it's my honor to be this year's chair of the Georgia Bar ADR section. This is the first of a number of programs that we're sponsoring this year. Some will be held via Zoom, others in person in Atlanta, and possibly Columbus and Savannah. Next month, we encourage you to attend an event that we co-sponsor with the Georgia Office of Dispute Resolution. On November 19th, we will be holding the 32nd Annual ADR Institute, which will be held at the State Bar of Georgia Conference Center in Atlanta. Today's program, celebrating the impact of ADR, creating peace and facilitating settlements, celebrates International Conflict Day. Conflict Resolution Day was established in 2005 to promote awareness of peaceful conflict resolution practices. Since its inception, easy for me to say, it has gained recognition on a global scale that encourages individuals and organizations to embrace conflict resolution as a means to build better relationships and communities. I want to thank Lane Sossaby, our program coordinator with the State Bar of Georgia, and most especially Scott Zucker. Scott is the program chair for this year's event and a past chair of the ADR section of the State Bar of Georgia. Scott is a seasoned mediator and arbitrator with Miles Mediation and the American Arbitration Association, and he's a partner at Weissman Zucker here in Atlanta. He's been practicing law for over 38 years. He is also the author of The Mediation Minute, Insights on ADR, which is available online. I hope that you enjoy the program today and learn from our panel of very distinguished presenters who will be introduced by Scott. And with that, I'll hand it over to Scott.
Thank you, Joyce. Wonderful welcome for everybody. And I'm really honored to reprise my role as program chair for this year's celebration of International Conflict Resolution Day. We joke that it should be a hallmark holiday, being the third Thursday of every October. And we're glad that as part of the State Bar, we can put on programming for you in celebration of the importance of ADR as part of our practice in the state, as well as those many of you who have joined us that are mediators or want to be mediators in the state. So a few housekeeping items. We have over 250 folks that have registered in attending this event, which is a record. Many from the State Bar, and also, again, there are members of the Georgia Office of Dispute Resolution. So I want to put in a plug for the GODR event, which is the ADR Institute on November 19th, coming up in about a month. So please register for that event, which should be incredible as well. I specifically want to thank Susan Guthrie, the former chair of the ABA section of ADR, who has helped me coordinate and obtain many of the speakers you're going to hear this morning. And she's wonderful to make the introduction and allow me to meet these wonderful folks that you're going to hear from today. I also, again, want to thank Lane Sossaby from the State Bar of Georgia, who this could not happen without him, and with the folks at the State Bar to help coordinate a program like this. So a few other housekeeping matters. Please keep your Zoom on mute during the programs, but please, if you have questions, go to the chat and put your questions in for the individual speakers. Each speaker is allotted about 10 minutes at the close of their session to answer your questions, and we'll be asking those questions from the chat area that you can put your questions into. Also, you'll be eligible, the lawyer's eligible for the CLE hours that have been approved by the State Bar, as well as the CE credit hours required by the Georgia Office of Dispute Resolution. So make sure after you finish this program that you submit your time for the credit hours to both the State Bar and to the Georgia Office of Dispute Resolution. So again, very excited for this morning. We're going to have 4 speakers. They're going to run pretty much in order. So stay tuned through closing at 1 o'clock. Let me turn to our first speaker, and his name is Michael Hawash. Michael is a veteran trial lawyer with extensive experience in litigation, mediation, arbitration, and what we're going to hear about this morning, early dispute resolution. Has a distinguished legal career, spans more than 3 decades, involving plaintiffs and defendants across various business sectors and industries. In addition to his law practice, he's a passionate educator, serving as an adjunct professor at the University of Houston Law Center. Yes, Michael's coming to us all the way from Texas. He imparts his knowledge through courses in ADR, legal negotiation, mediation, advocacy, case evaluation, and litigation risk analysis, and lectures on these subjects at law schools and bar associations around the country. And here we are, lucky enough to have you today, Michael. So I'm going to turn it over to you, and thank you for joining us.
Thank you, Scott, and good morning, everybody. It's always a challenge to go first in these things, but hopefully you've had your morning coffee and are ready to go. I'm going to talk to you about early dispute resolution, which is a new form of mediation, and it's the idea is it turns traditional mediation on its head, because what we do in early dispute resolution is we try to mediate much earlier in the case than is normal. The traditional model is that you litigate a case and you may mediate a few weeks or a few months before trial. And the whole idea of early dispute resolution is to try to do that earlier in the case, much earlier in the case. And I want to talk to you today about what it is, why we need it, why it works, and how you may incorporate it into your own practice. I've shared my screen. Is that showing up, Scott? Okay.
Yes, it is. Yep.
Okay, wonderful. Okay, so I'm going to be looking off to my side simply because of the way my screen is oriented. I need to look at my PowerPoint that way. But anyway, as a general overview, early dispute resolution, or EDR, is something that is a 30 to 60 day process. Unlike traditional mediation, where we may set a date in the future and hold a mediation, a month, 6 weeks, 3 months in the future. EDR is more of a process. It's a process that takes several weeks, where the mediator stays engaged with the parties over an extended length of time. And like I said, the purpose of EDR is to get mediation accomplished much earlier in the litigation cycle. It can really be done at any time of the litigation cycle, but ideally, in order to get the benefits of EDR, it's something that's done either before the claim is filed, right after the claim is filed, before discovery and motion practice. I'm a AAA panel arbitrator. One of the things that the AAA contracts often require is mediation before an arbitration is filed. EDR is something that can be done as part of that mediation process, and it's proved to be very, very successful. And let me give you a little bit about background about why it is that I'm a firm believer in EDR, and why I think advocates and neutrals should adopt this process. And it goes with lawyers and forecasting and predictions about case outcomes. And in a typical situation, when a client comes to a lawyer, the client wants to know about their case, and they always want to know what the lawyer's opinion is. What's going to happen if I bring this case? Do I have a case? What is going to happen? What is your prediction about how this case is going to resolve? And if you talk to lawyers, and I'm a trustee of the EDR Institute based out of Chicago, and we've done some studies on this by polling lawyers around the nation. And a lot of times when you ask a lawyer, look, if all you know about the case is talking to the client, how comfortable are you in predicting where this case is going to resolve? And lawyers, as a general group, say, I only really have about a 50% comfort level in predicting where this case is going to resolve, because clients don't always tell me everything. They tend to sugarcoat things. They tend to leave out important facts. And so I'd feel no more than 50% comfortable in predicting where this case is going to resolve. And you say, okay, well, let's go to the next step. Let's exchange documents. Now you have the key emails, you have the contracts. If it's a personal injury case, you've got a police report, you've got the the medical records. Now, how comfortable are you in predicting where this case is going to resolve? And lawyers oftentimes say, well, no more than 60%, because there's the other side's always has a story to tell. There's two sides to every case, and I need to know what the other side thinks. Say, okay, well, let's take it to that level. Now you can get with your opponent. You can talk about their case. You can talk to that lawyer about how they view the evidence and the law that it's applicable to any particular dispute. Now, how comfortable are you in predicting where this case is going to resolve? And lawyers, as a general matter, say, well, somewhere around 65%, because there's still some things I want to know. There's still some, discovery that I need to do. There may be some motion practice on the law that I need to do. We may need to get some rulings from the court. Okay, let's go ahead and open up the gates of litigation. Now you can go and spend, the next 2 years and $500,000 of your client's money. You can run down every single rabbit trail. And at the end of that, now how comfortable are you that you can predict where this case is going to resolve? And here was a surprising result. The lawyers said, well, no more than 70%. I'm not going to tell the client that I've got more than a 70% ability to predict where this case is going to resolve, because we can't control what the jury does. Arbitrators and judges often see things different ways. There are contested issues in the case that could go either way. And so the key to take away from this is we can get lawyers to that 65% level, where they feel somewhat comfortable about predicting where this case is going to go very, very early in the case. And that most of the expense in the case occurs after we get them that basic knowledge, that basic information about the case. And so if we can get the case resolved earlier, then oftentimes that's going to save a lot of time, money, and effort for the client. And so the only thing to really ask is, would clients rather resolve their case quickly, economically, and on the merits, even though some things may still be unknown, or after contentious, very expensive, continually more time-consuming and expensive discovery and litigation when the parties are exhausted and just really need to move on? And so what I would submit to you is that early dispute resolution is a better way. And what it is a four-step process. I'll go over the 4 steps with you. It can be accomplished in 30 to 60 days. It involves an exchange of what we call sufficient information, and I'll go a little bit more into that. It involves a rigorous risk analysis and a calculation of an expected value of the case that is typically done with a neutral's assistance. And we try to engage in principled negotiation on objective factors rather than traditional positional bargaining and mediation, where the plaintiff comes in with their best day in court and then some. The defendant comes in and their first offer is something less than defense costs. We try to get around that through principled negotiation. And it's really designed for the economical, fair, and early resolution of disputes. It's not just me that's advocating this. Last year, the American Bar Association unanimously passed Resolution 500, which basically resolved and urged all lawyers and interested parties to increase the voluntary use of early dispute resolution. So this is something that the ABA has seized on. It is something that law schools have seized on. EDR is being taught in many mediation classes in law school. Certainly we teach this at the University of Houston. I know that there's a specific class on early dispute resolution at Ohio State University. And so this is catching on nationally. and the or certain organizations, bar associations, certainly the AAA, is advocating the use of early dispute resolution. And in fact, early next year, I expect the AAA to be rolling out its own early dispute resolution rules. So what I'm going to be talking about are the protocols, the EDR protocols that are maintained by the EDR Institute. And the EDR Institute, I believe, is there's a bunch of different kind of competing early dispute resolution ideas of different ways different people have done it over the years. But the EDR Institute, I believe, has put the best protocols together. It started with a gentleman by the name of Peter Silverman, and he has gone around the country and got other EDR neutrals to contribute to these protocols. And so what they do is they're updated biannually, and they really do show what kind of the best thinking is on early dispute resolution and how to do it most effectively. There are guidelines for each step. They're flexible. They're not like rules of civil procedure. So some mediators may want to adopt some protocols, and maybe others won't be applicable to particular cases. But they are a very, very good place to start. They're maintained by the EDR Institute, and I'll give you that website at the end of the talk. What the protocols do is they have different ways that what we can do is start trust building within the mediation process. In some ways, it's bringing some collaborative law aspects to more traditional civil litigation. It has got protocols on how to communicate between the parties, how to overcome biases that we all have when we go into litigation. Protocols on negotiation. We talked a little bit about principled negotiation. I'll go into that a little bit later on. It tries to get people thinking more about probabilistic thinking rather than positional thinking. It does involve rigorous risk analysis and forecasting about what may happen during the course of litigation if cases are not resolved. So the goal of EDR is very, very simple, and that's this. Is to quickly and economically allow attorneys to attain sufficient information so their clients can have an informed judgment on settlement much earlier than otherwise may be expected in a traditional litigation model. So, as I mentioned before, EDR has 4 steps, and I'll go over them very quickly, and then I'll go into them in a little bit more detail. The first one is initial dispute assessment. The second is information and document exchange. The third is risk analysis and valuation, and that's usually done with the attorney and the neutral. And then the fourth one is final resolution, and that's usually through negotiation with the parties and sometimes a formal mediation that most of us would be familiar with. So let's go through each of these steps in a little bit more detail. So step 1, initial dispute assessment. There's 4 sections to this, and it's gaining material facts, understanding what the core claims and defenses are, what are the documents that are needed in order to have sufficient knowledge or sufficient information in order to give a client informed judgment on where this case may resolve, what a pathway is to resolution, and whether or not an expert is going to be needed in order to have sufficient knowledge. So this is a very important step, so I'm going to go through it in a little bit of detail. So material facts. What are the material facts of a case? If it's a contract case, it's, what does the contract say? What are the emails and behavior of the parties that may show what a course of performance is? What are the facts or information that led to the breach of that contract? And what are the damages that are associated with it? In a personal injury case, it might be, say it's a simple car wreck case. It might be, the testimony of the individual drivers that were involved in the accident. It might be the medical records, a police report, the basic facts that you need to be discovered in any type of personal injury case. Similarly, the core claims and defenses are what are the core, we've talked about what the factual elements are. Now, what are the legal elements? If it's your standard commercial breach of contract case, you may have a breach of contract cause of action. You may have a fraud or a misrepresentation cause of action. In your personal injury type matters, typically you're going to have a negligence cause of action. And so it's just identifying what the core claims are and what the defenses are to those claims. And then the third thing that you do in this initial step is what documents and information are needed for sufficient knowledge. And this is really kind of a two-step process, because the client, the plaintiff, generally, they're going to have their own documents, and the defendant is going to have their documents. So as a neutral, as you're bringing the parties through this first step, you need to be asking the attorneys, what documents do your clients have, and then what documents do you need in order to give your client informed judgment on where this case might settle. And then in some cases, a retained expert may be needed in order to have sufficient knowledge. Now, let me go on this a little bit, because what we're trying to avoid here is a battle of the experts. And what I tell people when I'm putting people through an EDR, they say, well, we need to go ahead and get an expert witness in order to do this. I'm like, look, I've been practicing law for a long time. Generally, I can write the expert's report. We all know what the expert's going to say. If you know what the expert's going to say, you don't need to have the expert put it down on paper so you can give it to the other side, because the other side typically knows what the expert's going to say as well. Now, there are instances where an expert may be required. And there's two ways to handle this as a neutral. You can do, since discovery generally hasn't occurred yet, you can do a sufficient knowledge expert report that is not going to be allowed in litigation. So it's kind of a preview of an expert report. Sometimes parties have engaged a joint expert. I had one EDR where the chemical composition of a bolt basically was in dispute. And so the parties engaged a joint expert in order to determine what that chemical composition was. In another case, there was some documents that were in Vietnamese as well as English. And so the parties hired a joint expert to do the translations for them. So they could put the Vietnamese documents into English where the parties could use them in the EDR. But as a general matter, we try to avoid using experts in the EDR because there's so much expense related to that, that if we can't avoid it, we will. All right. So now we go to step 2, which is information and document exchange. And so what the parties will do is, and it's generally controlled by the neutral, is there's going to be an exchange of documents. And so after the party assembles their own documents, they may give some requests to the neutral in order to get documents from the other side. Now, this isn't full, everything go down every rabbit hole, kitchen sink discovery. It's what are the material documents that we really need, both sides really need to see in order to try and resolve the case. And then once those documents are assembled, then generally the neutral will do a simultaneous exchange. The document exchange may promulgate some additional requests for information, and that's something that the neutral can assist the parties in doing. There is a provision for questioning witnesses. I'll go into that in a little bit. And then if there's other needs, for example, I do a lot of construction mediations. And so what we might do is organize a site inspection for one side or the other, and all of that can be coordinated through the neutral. So let's talk about questioning witnesses, because this is something that comes up quite often. And there's some protocols within the EDR Institute's EDR protocols that deal with this specific issue. And basically, if needed to develop sufficient knowledge, the parties can ask questions of the other side's witnesses. And kind of like a corporate representative deposition, the topics should be disclosed in advance. The witnesses should be candid, so it's a little bit different than a traditional deposition where the witnesses are coached not to say anything. And then the biggest question here is it going to be on or off the record? And the default here is generally going to be off. Here in Texas, we have a pretty broad ADR confidentiality statute where communications made within the context of a mediation can't be used in a court of law. Typically what the parties do if they're going to allow short depositions to occur in an EDR process, then they'll incorporate that ADR statute into the deposition notice. So since full discovery has not been done, what the witness says can't necessarily be used against them. And this could prove to be quite successful in getting basic information about the case, but also alleviating lawyers' worries about putting people up for a deposition when they may not know all of the facts. Okay, so one of the things that is important about early dispute resolution, is we don't have a judge in this case. There's no one that can go and sanction the parties, if they're engaging in discovery abuse or that sort of thing. And so, we try to build into the protocols certain safeguards to give the parties comfort that they are getting all of the information that they are entitled to. And so, those of us who can remember back in the Reagan days when we were trying to do some strategic arms reduction, we called it trust but verify with the old Soviet Union, and that's kind of basically what the idea is here with early dispute resolution is trust but verify. And so we have what's called a verification of a compliant response, which is generally an affidavit type of document that basically the client signs that says that they've read the requests that the other side have provided, that they're not withholding any information, and that the witnesses' answers have been accurate. There's a form on how to do this at the EDR Institute's website, but this verification of compliant response, I let the parties know, look, as you're responding to these informal requests, even though it is in a non-litigation type setting, whether it's in the context of an ADR proceeding, we are going to require you to go ahead and verify these responses. If they fail to do the verify the compliant response, then the party must withdraw from the EDR. If one party or the other believes that the other party is not behaving in good faith and is withholding documents, they can withdraw as well. EDR is a voluntary process. And, one of the reasons for having this is they can incorporate their reliance on that verification of the compliant response into a settlement agreement. And so the settlement agreement could be avoided for fraud in the inducement if it turns out that something is incorrect. I know that around the country, various courts have allowed even fraud in settlement agreements if you have certain magic language that non-reliance type clauses can be put in there, but that's something for the lawyers to work out if they reach a resolution. All right, so the next thing we get into after we've exchanged, the lawyers have identified the material facts for the case. They've gathered their own documents. They've made their requests for documents for the other side. The neutral has facilitated that exchange. And now what we're going to do is engage in step 3, which is a risk analysis valuation. And this is where I think the neutral really earns their spurs on helping the parties reach a resolution. And the goal here is resolution through informed judgment. And there's a little bit of a different mindset that I try to impart upon the advocates in an EDR resolution or an EDR mediation. And it's this. In law school, we're often taught, and many of us who are litigation practice have learned that litigation is a battle. It's a war. We have a soldier mentality. Somebody's got to win. Somebody's got to lose. And what I try to do in EDR and in mediation in general, really, is have more of a scout mentality. And what do I mean by that? I mean that we look at the dispute as advocates as a challenge. And when scouts reach a challenge, what they do is they try to make a map to get around that challenge. How is it that, when roadblocks come up, it's not that we beat those roadblocks down, it's we try to find a way around them. And so I'm not saying that advocates and who are engaged in EDR need to stop being soldiers, but I think they also need to be scouts. Zealous advocacy also demands zealous problem solving, and those are the types of EDRs I think that are most successful. Once when the neutral is engaging in this step 3 with risk analysis with the parties, this is kind of a chart of the different steps of that risk analysis that you go through, and these are complementary factors. The factors on top are generally monetary ones, and the factors on the bottom maybe have some link to monetary issues, but sometimes are a little bit more subjective. And the risk factors that we go through are this, is, future costs. If we don't get this case resolved, how much is it going to cost in order to get this case to trial? And this would include all of your expert expenses, your deposition costs, attorney's fees, you name it. And oftentimes the parties are particularly the clients, are shocked at what that number is. And then, when you ask the attorneys, what is your percentage likelihood of prevailing? If you establish all of these facts and you go to trial, what is your likelihood of prevailing? And then what do the damages look like? What is your best day? What does your worst day look like? And what does the most likely day look like? And getting the attorneys to start thinking about, where this case, if this case, if it goes for them, if they're the plaintiff, or if it goes against them, if they're the defendant, what does a damages award look like? And if you get all of that information, you will be able to determine what the risk-adjusted value of the case is. And I'll show you a little bit about how we do that in a minute. But these are just the monetary factors. I mean, you can determine the risk-adjusted value of the case. That's not necessarily where this case should settle. There are other factors, more subjective factors, that also should be considered. And here's just a few of them, or at least the big ones that I see often in EDRs. And one is risk tolerance. One party may have a much larger risk tolerance than the other. If you're dealing with a very large company and a very small lawsuit in relation to their assets, their risk tolerance, they may not care what happens in this case. If you're dealing with in a personal injury case with an injured worker who has questionable, very, very serious damages, but questionable liability, and their ability to provide for their families is going to be seriously diminished, their risk tolerance may be very low. They may need to get some money out of a lawsuit rather than no money. So understanding the risk tolerance of the parties is absolutely essential for both the neutral and the advocates to understand. There may be business interests that are involved. Perhaps there is an ongoing relationship between a customer and a client, between a supplier and a manufacturer. Oftentimes, these business interests need to be explored and understood in order to successfully tackle the case. There are leverage factors. If one company has a lot of money and the other company has very little money, they're going to have leverage, an ability to outspend somebody in litigation. There may be other leverage factors in continued contracts or other things like that need to be examined. And then finally, you would be remiss if you didn't assess what is the collectability of a judgment. You can have the highest damages model in the world, but if the defendant doesn't have the money to pay it, and all that judgment is going to do is become a nice piece of paper that you can frame on the wall and say, look what a great lawyer I am, because it's uncollectible. That's something that really needs to be addressed at the earliest phases of the litigation rather than later. My good friend Sam Ardrey, put these risk analysis factors in what he called the 5-finger risk analysis, where you can just hold your hand up as a neutral, hold your hand up to the parties and let them know, what happens in this case. Do you win or you lose? What's the percentage chance of that? If you get a conservative jury, what are the damages awards? If you get a generous jury, what's the damage awards? How much is going to cost? And then what are these other things, these other intangibles, the business interest, the risk tolerance, the collectability? Just a little trick that mediators can use, or it's not a trick, but a narrow that mediators can use in their discussions with the parties, and particularly with clients. So I've talked about having to think probabilistically instead of just shooting from the hip. And what do I mean by this? This is a slide that shows what lawyers say and then what clients hear, and what lawyers mean can often be very, very different. When you go in as a neutral and you ask the lawyer, what do you think about your chances in this case? And they said, these are the types of things and answers that I often get. We have a reasonably strong case. Well, what does the client hear when they hear the lawyer say we have a reasonably strong case? We're going to win. That we've got 100% chance of winning. When a lawyer says this is a tough case, what does the client hear then? Do they hear it's a 50-50 case, or is it a 20-80 case? It's not really giving the client any information. We're facing an uphill battle, the same thing. What does that really mean? And then there's my favorite one is I like our chances. I mean, if you're the client and you hear I like our chances, what does that mean in how this case is going to turn out when it finally gets before a judge and a jury or an arbitrator? And so in EDR, what we try to do is talk about probabilistic thinking, and what are the percentage chances that these things are going to happen, and then we can arrive at a risk-adjusted value of the cases. And I'm just going to do this little exercise for you, and just put your answer in the chat. Just think about where this case, if you got this case and you heard, well, we've got a 50% chance of winning. The damages are 100,000, 200,000, or 500,000, and there's a 33% chance of damages at each level. The future fees through trial are going to be $75,000, and there's no fee shifting, so there's no going to be attorney's fees award. Just what's your intuition on where you think what this case is worth? Is it a $200,000 case? Is it a $125,000 case, or is it a $50,000 case? And just what's your intuition? Throw it in the chat. I'll give you a few seconds. My time is limited, so I'm gonna move quickly. And so the answer is $58,000. And I've taught this around the nation, and what most people gravitate to is that $125,000 number, when it's actually about half of that. And this is a decision tree. If you're not using decision trees in your mediation practice, I highly recommend that you do so. When we do formal training on EDR through either the AAA or the EDR Institute or through law schools, this is a big part of the risk analysis section, is how to do decision trees. They look complicated, but they're actually very, very easy to do. And basically what they do is they come up with a risk-adjusted value of the case based on the attorney's own assumptions about their chances of winning, what the damages look like, and what the percentage chances that they're going to get damages at different levels. This is done with a free program called silverdecisions.pl. Since this is a web-based program, you never want to put any type of identifying information into a decision tree when you're creating one of these things. But there are ways, there's YouTube videos and all sorts of things that you can look at in order to learn how to build these things. And there's different courses that you can register to in order to learn how to build decision trees. They're enormously valuable for mediators, and I highly recommend that you look at those if you haven't looked at them already. I suspect ChatGPT and some of the other AI models are now getting pretty good at building decision trees, but it really, in order to use them effectively, you really need to know how they're built and the logic that goes into them in order to use them effectively into a mediation setting. And so we come up with a risk-adjusted value, and a lot of time that's asking the lawyers, what is the what do you think the percentage chance is that you're going to win this case? What do you think the percentage chances of where damages are going to be? And so judgment is coming into this, and lawyers have to have that judgment, but then that judgment is refined during this risk analysis process, by things that the other side is saying. We try to temper biases. We try to get away from positional bargaining and more into probabilistic thinking, using decision trees and that sort of thing. But we also have to recognize that our knowledge is incomplete, that when if you go and create a decision tree with a lawyer early in the case to say, here's kind of where the risk-adjusted value is, you may have to adjust the numbers on that depending on what the other side says. As the sides start negotiating and they start emphasizing different facts, different arguments, then you may need to adjust what that risk analysis looks like. Once you've done the risk analysis, you get to the final resolution step. So let's go over kind of what we've done so far. Using the risk analysis, the parties are going to attempt to negotiate a resolution, usually with the neutral's assistance, and that will be done informally over telephone calls, maybe some Zoom meetings. If you're unable to settle the case informally, then what you do is you'll just schedule what we would all recognize as kind of a traditional mediation with the EDR neutral. And if that mediation does not resolve in a settlement, then there's other things to consider rather than just immediately going to the courthouse. The courthouse isn't going anywhere. It's always going to be there. If there's certain issues that are preventing resolution, then consider either binding or non-binding arbitration, maybe on that issue. There was one case I had where it was a statute of limitations defense that was preventing a settlement. What the parties did is they went and hired an arbitrator for a one-day arbitration just to deal with the statute of limitations issue. Got a resolution on that, and we were able then to go and get the case resolved. So even if you don't resolve in the case in EDR, there are massive benefits associated with it. At the very least, after going through this process for 30 to 60 days and all of the different steps that we've discussed, the party should at the very least have narrowed the issues as to what the case is about. There's options. You can engage in limited discovery if needed, and then re-engage the neutral in order to try to get the case settled. You can try and agree on another type of procedure, like as we talked about, either non-binding or binding arbitration. You can consider an offer of judgment. And so all of these things that can be considered if you don't resolve. But I will say this, I've never had a party go through an EDR and say, gee, that was a waste of time, because at the very least, they've learned an awful lot about their own case, and they've heard an awful lot about what the other party thinks of their case. So people come away from this process very, very informed. And so the secret sauce of EDR, why it works, is when you look at the protocols, there's certain ethical standards that require a certain amount of cooperation in what has traditionally been a very adversarial process. They are carefully drafted rules of cooperation and engagement, with these safeguards like the compliant response that I spoke about. You do need this lawyers with skill who can separate what's important from the case from what's not important. This happens most often when you're talking about document exchange. What you really need in a document exchange are the key documents. What in a commercial case, what's the key contract? What are the key emails that show the various elements? It's not give me every single email between the parties from 2015 to the present. Being able to distinguish between what's important and what's not important can be important, and the protocols help with that, and the neutral will assist with that. And then you apply the best thinking, I think, on risk analysis, an objective use of risk analysis tools in order to help the parties arrive at what a risk-adjusted value of the case is. And this is my little kind of concluding graphic of what litigation looks like, and then the 4 steps of EDR. I'm been asked to leave a few extra minutes for questions, so I can do that. For additional information, people can always email me at michael@houstonmediation.com. And then the EDR Institute's website is the EDR institute.org. And there's all sorts of forms there on how to incorporate EDR into your practice, and when training sessions are, if you want to have more formal training in either the process itself and or risk analysis. And so I can open it up for questions.
Yeah, Michael, we're gonna join you here to ask you a few questions that I've gotten in response to your. First of all, thank you very much. I mean, the topic of EDR is relatively new for many of us. So for you to walk us through the process is really interesting. But I think the questions I'm getting go to the training and certification, and maybe I would call it marketing, of being an EDR neutral. So can you walk us through, I mean, other than the Institute or the AAA or ABA, I mean, tell us how people can become an EDR neutral.
So I think through the EDR Institute, there is, they typically offer training. It's one of the places that the Institute has been thinking about offering training, and they haven't yet, is Atlanta. And so that would be particularly useful. And if someone probably did an overture to the EDR Institute, I'm sure that a training in Atlanta actually could be done. I know that they've done it on on both coasts and in Texas and then in Chicago. So they've kind of hit, around the country. But Atlanta is a big legal market, and I think that would be an attractive place. The as the AAA rolls out their EDR rules and encourages EDR, I suspect that there's going to be more course offerings through the AAA that will be coming up. And then the EDR Institute is also working on that should be coming out very soon. It's a video that you can do, kind of a self-paced video where you can take it's a 12-hour course on EDR. What I gave you is just a very, basic, 45-minute overview. But in order to become an EDR neutral, and you need to go into a lot more into the how to accomplish those document exchanges, how to do the risk analysis, how to put make the parties think about cases probabilistically instead of that positional bargaining, and all of that has gone through in the training in great detail.
So there is ultimately a certification that people could obtain to then market themselves as EDR trained?
Yes. So one of the things, if you do take the EDR Institute's training, then you become eligible to be listed on their website as an EDR certified neutral. Here's what the advantage I think for EDR is for a lot of people, and it's certainly been that way for me, is one of the things that new mediators want to do is they want to be able to differentiate themselves from the pack that's been doing this for decades. And a lot of the younger mediators are EDR trained, and a lot of the older ones are not. So it's one way to kind of separate yourself from the pack and give yourself some extra arrows in your quiver, so to speak, to help you go through or have some additional skill sets that other mediators don't have. And I think what you're going to find is, just a few years ago, EDR was, relatively unknown. There were some articles that have been written about it. There was a couple of books that have been written about trying to adopt it, but it hadn't really got the penetration that it needed. And I think the catalyst was the pandemic. And when the pandemic occurred, what happened was, one, we had the proliferation of Zoom, and here we've got a process that is particularly well suited to video conferencing and Zoom type mediations. And so, all of my EDRs, quite frankly, are done via the phone and Zoom. So the technology's in place and people are comfortable with the technology in order to do it. And then the other thing that happened is we started getting dockets that were way backed up, and we're still dealing with the at least in Texas, we're still dealing with the pandemic backlog of cases. And so this has been particularly attractive to judges who want to get cases off of their dockets, move cases along. We've got judges now in Harris County that are sending out EDR letters at the beginning of cases. There are federal judges who are ordering parties into EDR. They've got case administrators now that are identifying what types of cases are best suited for EDR. And so, employment cases, really good for EDR. Commercial cases where there's an ongoing relationship between the parties. Construction cases where you're in the middle of a construction project. All those types of cases are really good for EDR. Other cases that are great for EDR are, and it's been particularly successful here in Houston, are county court cases, which tend to be, smaller cases where the amount in dispute is less than $500,000, a lot of times less than $250,000, where the accumulation of attorney's fees makes that case unsettlable very quickly. Right? If you go through a traditional case, and you're talking about a $250,000 dispute, and all of a sudden the lawyers are charging and the case expenses are $100,000 each or more, then somebody has to win and somebody has to lose. And it becomes very, very difficult for the parties to get the case resolved. And so if attorneys can recognize that at the beginning of the case and say, let's do EDR, what they lose nothing. At the very worst, what they've done is they've learned a lot about what their case is about. And so I suggest it in every case where I'm still an advocate. In some cases, I'm somewhat of a recovering litigator. I'm trying to shed myself of that. But in every case in which I'm an advocate, I am, recommending EDR, and oftentimes we're getting the cases resolved.
So in that same context, another question, and maybe we missed it, with regard to the parties entering into a written consent for EDR. Is there like a mediation agreement? Is there an independent EDR agreement to agree with regard to the production of information and the answer of these questions? Can you walk us through what that agreement might look like?
Sure. So yes, you do enter into a specific EDR agreement. There are forms that are available on the EDR Institute website about what that agreement may look like, where you talk about the process and, the parties are basically agreeing to, cooperate in good faith in order to, with the EDR and they also usually incorporate the EDR protocols. Here's one of the key things that needs to be part of that EDR agreement. And then that's this. Is confidentiality of the process, confidentiality of the exchange of information, confidentiality of any witness statements, or confidentiality of expert reports. As a general matter, EDR really is a form of dynamic mediation, right? But it's so new, has a court ruled that? So it would be like, for example, in Texas, where we have our mediation statute, no court has yet ruled that an EDR is a form of mediation, so it would be part of that statute. Now, I can't imagine a situation where a court would rule otherwise, but boots and suspenders, you always want to make sure that confidentiality is part of that EDR agreement.
And another question with regard to giving an example of a binding resolution process versus non-binding resolution process in EDR.
Right. So, sometimes particular issues will prevent a settlement. We've all been in mediations where one party has just a completely opposite view of the application of facts and law. And the mediator may try to sit there and say, okay, help one party or the other in sorting out what the facts and law actually mean. But people become entrenched. People become, we all have kind of confirmation bias on our own cases. And so, what I could do as an EDR neutral is I will recommend an arbitration in order to resolve that issue. And it can be binding or it can be non-binding. So it can be, look, you guys can go hire an arbitrator for a day, rather than going down and spending $500,000 of your client's money, over the next 2 or 3 years, because you guys are stuck on this one issue, go spend $10,000 or $15,000, hire an arbitrator, a former judge or a respected arbitrator that you can both agree on for a day to resolve that issue. And, you can do it in a binding way where that is the issue resolved for all future litigation, or you can do it in an advisory way. You can get a third party's view of the case, and then you're not bound by it. But having that third party come in and decide that issue for you, even in a non-binding manner, can often be what breaks an impasse in mediation.
Another question, I really appreciate the audience submitting these questions, because it's really an interesting and an evolving topic here. Is there a version of EDR in family conflict resolution, such as divorces or child support and custody matters?
It's a great question, and it would be, I don't know how it is in Georgia, but I can tell you how it is in Texas. And I don't do family law myself. I'm primarily a commercial litigator dealing with construction and insurance issues related to construction and that sort of thing. But you know, collaborative law has changed the family law landscape where it used to be that everything was adversarial, and now collaborative law has really made inroads into the family law practice. What the granddaddy, if you want to say, of EDR really was the experience of the family law lawyers. That what we wanted to do is try to bring some of those techniques that have been so successful in family law and try to bring them into a commercial litigation arena, which tended to be much more resistant to collaborative law type of efforts. So that's kind of a long way of saying that really family law and the collaborative developments in family law was really what has bred EDR. I have not used it in a family law setting, but that's just because I don't practice family law. I'm sure that there are family law practitioners who would use EDR, and I think if family lawyers went and looked at the protocols, and the protocols are available free online at the EDR Institute website, I think that what you would see in there are a lot of tenets or a lot of ideas that are geared towards a more collaborative resolution of disputes, and would find them valuable.
And I guess I have time for one more question for you with respect to the strategy of EDR. And this maybe go a little opposite of the philosophy of what you were talking about earlier. Do you see folks sort of holding their cards next to their chest on some of the issues that they want to hold back as part of this process? Or are you having the philosophy of a full disclosure, let everything on the table sort of issue in terms of resolving these cases through EDR?
Yeah. So yeah, I mean, what we're talking about really is kind of the smoking gun discovery, right? And what I tell parties is this: if we don't get this case resolved, then the smoking gun is going to be discovered, right? At some point, you can go and you can try to hide things, and there's going to be motions to compel. There's going to be a lot of money spent, and eventually, everything is going to come out. I think it's if you're dealing with lawyers that are going to deep six documents and clients who are going to hide documents, whether you do that in EDR, you do that in litigation, they're going to try it in both instances. EDR there is a certain amount of good faith that's required. If parties know or have an idea that certain documents exist and they're not being produced, then this is a voluntary process. It's just like mediation. If you don't like the way it's going because you don't think that one party's playing fair, you can always get up and leave. You can do the same thing in EDR. This is a voluntary process that's supposed to be for the benefit of clients. So if one party's not playing by the rules, if one party's not being fair, that's fine. Like I said, like I tell you, the courthouse is always open to you. You can go there and pursue motions to compel and everything else. Oftentimes, I don't think that's necessarily in the client's best interest, because in my experience, these documents generally come out. So what we do encourage in EDR is the full disclosure of documents, and that's one of the reasons why excuse me, we have that compliant response that I talked about. We're basically, not only, in traditional litigation, clients are signing interrogatories verifying interrogatory responses. They're not necessarily verifying requests for production. In EDR, we are having them verify those requests for production. So hopefully that's going to solve the deep sixing, the smoking gun document, with holding things back, because the client's going to be asked to sign basically an affidavit stating that they've produced everything.
Okay. Time for one more question, and we do have one more question, although it's
Sure.
an interesting question, because I know this is early dispute resolution. But the
Right.
question goes to whether EDR could be effective later in
Yeah.
a case before trial where the parties have really maybe gone through the process, but want to try to use EDR in lieu of trial.
Yeah. I mean, it really is it's really kind of more like mediation on steroids, right? It can be used at any time during the process. It was initially designed to be used very early in the process in order to benefit the clients and the public at large from spending an awful lot of money on lawsuits. We got to remember, there's an adage in the law that 95% of all cases settle. When you go and you actually look at that data, that's not true. It's people, not 5% of cases don't go to the jury. It's less than 1% of cases go to the jury. The rest of them are resolved mainly through settlement. And so the whole idea is, if it's going to settle anyway, let's find the most economical time to settle it, rather than after all of the expense and all of the judicial resources have been used. And what EDR does is it sets up a process for that. It's designed to be done early in the case, or either before a lawsuit is filed, right after an answer is filed. But of all the techniques that I just talked about, they really can be done at any time. And oftentimes when people come to me to mediate a case that maybe it's been going on for 6 months, a year, or 2 years, sometimes depending on where they are, and what I learned during my pre-mediation conferences is, these people really do need to go through an EDR. And so I'll borrow some of those techniques from the protocols and, put them through an EDR, even though we might not technically call it an EDR.
Well, Michael, I really, really want to thank you for taking the time this morning to speak to us and to educate us on a really innovative topic that I think many of us have now learned about, maybe for the first time. And maybe we'll revisit with you in the future about being educated and led more into learning more about EDRs. But thank you for your time this morning. On behalf of everyone here and over 250 people, thank you for taking the time and joining us and celebrating Conflict Resolution Day with us.
Thank you very much, everybody. Appreciate the
Thank you.
opportunity.
All right. Next up, I guess we find Dr. Wolpe. I want to really tell everybody how excited I am there he is. Hey, Paul. I wanted to tell everybody how excited I am that I finally got Dr. Wolpe to join the State Bar to participate in a program because of his work in the ADR and peace building process. Dr. Wolpe, who's out of Emory, is the Raymond Schinazi Distinguished Research Chair of Jewish Bioethics, Professor of Medicine, Pediatrics, Psychology, Sociology and Neuroscience and Biological Behavior at Emory University. He stepped down last year as director of Emory's Center for Ethics after 16 years, and he is building a new center called the Emory Center for Peace Building and Conflict Transformation, or otherwise PACT. There's a lot about Dr. Wolpe here, but he was also named a Trust Across America's top 100 thought leaders in trustworthy business behavior, won the 2011 World Technology Network Award in Ethics, the 2022 SEDEC Award from the New Israel Fund for Work Supporting Peace in the Middle East, and the 2025 Humanitarian Award from the International Center for Missing and Exploited Children. There's so much more about you, Paul, that I could tell this audience wonderful history and resume. I've heard you speak numerous times. I can't wait to hear about this particular presentation of your travels in learning peace building as you build the Emory PACT Peace Building Center. So welcome this morning. Thank you for joining us.
Thanks so much. Can you hear me okay,
Yep.
Scott?
Yep.
Great. Hi, everyone. This talk's going to be a little different than the usual talks you get. It's not going to be about the process of mediation or dispute resolution. It's more a global view of how these things are thought about. So let me just start my slides here and tell you a little bit about how this all happened. So as Scott said, I was the head of the Center for Ethics for many, many years. I'm actually a bioethicist by training. And when that opportunity arose that I stepped down and there was something else I could do, the university asked me if I would build another center. And so I asked what center they had in mind, and they left it up to me. So I decided that what we really needed today was a center for peace building and conflict transformation. And as you'll see towards the end of my talk, I think that there's a micro reason. I've noticed over almost 40 years of teaching our students less and less able to have difficult conversations, especially across ideological boundaries. And also, I don't think that's just a problem of our students. I think we've all seen it in our friends and peers. And then the macro reason has to do with Atlanta as a city with its unique resources. So I'm going to tell you about that. First, I'm going to go through some of the experiences I had because I took that first year off and went on sabbatical and visited many peace centers around the world. And I want to tell you especially about a group in Europe that I visited. And then I'll lay out what I'm trying to do at the at PACT, the Center for Peace Building and Conflict Transformation. So I think our ability to talk to each other in a way that demands true listening has been compromised. As Joseph Epstein, the author, once said, people don't listen, they wait. They wait till the other person's done speaking so that they can then tell them their refutation and their point of view. But deep listening is an art we seem to have lost. And so there was great, very positive reception when we talked about launching this new center. So I went to Europe for 14 weeks. I visited cities all over Europe that had some major peace building or conflict resolution or mediation functions, 19 cities, 32 centers across Europe. It was a pretty extraordinary experience for me. It wasn't my field to begin with. I've done mediation many times, and my function as an ethicist and clinical bioethicists are mostly mediators. But this was a broader platform. This was people who did mediation all over the world, who did mediation in major war theaters, who some of them were involved in Israel, Palestine, some of them were involved in Ukraine, Russia. And so I got a kind of snapshot that most people don't get. In fact, these experts who I visited with, when they heard that I was visiting 31 centers, were extraordinarily curious to find out what I'd find because they themselves haven't had that kind of broad experience. So this is just a quick list of some of the programs that I visited internationally, in mostly Europe, Israel, and Pakistan. Just a quick thing. Unfortunately, when I got back to Emory after that part of the trip, because of economic changes in universities that I'm sure many of you are familiar with, Emory froze all travel. So planned trips to the Middle East and Africa did not happen, but they will happen slowly in the future rather than all at once. So this is mostly a view from Europe, though, as I say, it also includes Israel and Pakistan. And you'll notice that many of these organizations, for example, the Hague Institute for Global Justice, they look at these questions on a global perspective. The Senator George Mitchell Institute for Global Peace, they're really trying to look at the question of how we can mediate for peace, not just in particular conflicts, but try to create the grounds for lack of conflict through their own kind of early intervention. Then when I got back, since I traveled the way I had planned, I instead went around the United States, which I'd planned to do later, and visited peace centers in the major peace centers in the United States, which included a number in Washington, and also the Kroc Center. Joan Kroc created two centers, one at the University of Notre Dame, one at the University of San Diego, very major, important peace centers in the United States. And then, of course, spoke to many, many of the people that work in this area in various ways in the Atlanta region, and in fact, spoke recently at the Atlanta International Arbitration Society. Spoke to a group of lawyers that do professional arbitration. So this is just a sense of all the different places that I went, and I want now to give you some of the wisdom that I gleaned talking to these extraordinary people who've really dedicated their lives trying to create peace or to solve conflicts on an international scale. So conflict intervention, as some of you may know, on this kind of theater, an international theater, has what it calls tracks, and there are 3 tracks. And track 1 is really that high-level conflict intervention, state-to-state actors, United Nations, NATO, major international interventional bodies, military bodies, and some organizations focus primarily on track 1. They are really the ones that try to facilitate high-level political dialogue. Track 2 includes large organization, major businesses and NGOs, major academic institutions, regional or state level actors. So they're kind of the intermediary actors, or intermediate actors, I mean. And, some places will say, well, we are at track 2.5, meaning what we try to do is we try to mediate between the track 2 organizations and the track 1. And then finally, track 3 is community-based. It includes small NGOs, local political organizations, community groups, and a lot of the groups I talk to work at that level or at level 2.5, trying to create local and regional either organizations or intervene at that level to solve regional conflicts. So when you speak to these groups, very often they will just assume you know these tracks, and they'll say, yeah, we're a 2.5 track organization. But it's a fascinating way to parse things by size rather than type. But that's how they do it in these peace organizations. So I'm going to talk about a few cities I went to, and here's just an opportunity in the next slides as I go through these cities very quickly to show you how beautiful Europe is and why 14 weeks there was just delightful. So we're going to talk about Geneva, which calls itself the City of Peace, spends $30 million a year promoting itself as the City of Peace, has an enormous peace industrial complex. Basel, another city in Switzerland, Basel, Zurich, and Geneva fight to be the recognized cities of peace. Basel just stole Swiss Peace, the largest NGO, from Bern, Switzerland, moved the entire organization up to Basel, gave them a building and many millions to move their whole organization. So it's a very competitive environment in Europe around peace. We'll talk about Edinburgh and then finally London. All right. So, I'm sorry, and then London, Belfast was perhaps the most interesting city of all. I'm going to spend the most time on Belfast. So let's start with Geneva. This is the Geneva Graduate Institute. It was founded by the League of Nations in 1927 as an institute for peace and diplomacy. It's enormous. It has many, many divisions. It has hundreds of graduate students in various programs. It takes up more than a couple city blocks in Geneva, and it is a powerful player in the international peace community, and certainly perhaps the lead institution in the world in peace education. They were the ones that said peace needs to be thought of in a very robust way, not just as the cessation of hostilities, as we'll see in Belfast, for example, but rather as a positive movement forward, the kind of thing we're seeing right now in Rwanda, where they're trying to repair that horrible genocide and see if there's a way that Hutu and Tutsis can move forward together as a country. And in order to do that, you need to address past grievances, and we'll get to that in a moment. The most important thing, as I'm sure you're all aware, is trust. You cannot go into an area where there's hostility and fundamental mistrust and also be mistrusted, or else your work can't really succeed. And also, I heard this message a lot throughout Europe. Europe had dominated peace studies for most of the 20th century. Moving into the 21st century, I heard over and over again the kind of dominance of the white European peace intervener is slowly been eroded and in some ways has been lost. And the countries that you heard mentioned over and over again as trying to move into that space were China, Turkey, India, and Qatar. And as we see that with Qatar making its move in the Middle East and now in this country as well. Because Switzerland is Switzerland, Geneva has created its own independent strategy for this, really independent of Switzerland. And Geneva really has to be considered the premier city in the world for peace services. They have a very developed infrastructure to send people out or bring in representatives to mediate for peace. Swiss Peace, the organization that Basel stole, is a fascinating organization. They have a subgroup called Dealing with the Past, which works in transitional justice. Those are here you see some of the ways in which they structure that every group has a right to truth. You can't hide things. You need to be fully disclosing, and a right to justice, which means a right to some kind of reparations if they were wronged. And then some guarantees of non-repetition. And here's what the goals of here's how they structure or think of the goals of what they call transitional justice, things like restoring public trust, seeking post-conflict reconciliation. You can hopefully read some of those. So they have a very elaborated structure set out for how they try to do their work. And they have this justice, reparation, non-recurrence, truth kind of mantra that they use, that justice has to be felt. That is, people have to feel that justice was done in the wake of injustice, that some kind of reparation, it's not always monetary reparation, but some kind of reparation has to show that the parties that were aggrieved have been heard by the other side, some structures put in place for non-recurrence, and then truth, as in things like the Truth and Reconciliation Commissions. In Rwanda, for example, they have the Gachichi courts. These are extraordinary courts where groups, you can see pictures of, more of the rural tribal groups. They're all sitting on the ground. People get up and say, yes, I was part of this. I killed this person's family. I'm so sorry for that. And then if there's anything you want to know about how your family died, I'll try to tell you. And then the person whose family was killed stands up and talks about how it affected their family, and then asks whatever questions they want. And this is all about trying to establish a basis of truth. We'll tell the truth about what happened, but also as a process of trying to move forward beyond it. This can't be imposed. You can't come in and make peace. You can only facilitate peace. And there are right and wrong times. There's a temporal dimension to this. People specialize in different places along that path to peace. There are some societies and some conflicts that aren't ready for conflict resolution. And there are people who go in and try to facilitate that and help community organizing and other ways to get groups ready for some kind of conflict resolution. There are people who specialize in just pre-conflict resolution organizations, setting up the actual times, structures, demands before formal conflict resolution. Then there are the mediators who do the conflict resolutions. Then there are the post-conflict resolution experts who come in and try to keep the process going and deal with issues as they come up past that. So Swiss Peace does that all over the world. It's quite a remarkable organization. Edinburgh is interesting because Peace Rep, which is this organization you see down at the bottom of the screen, Peace and Conflict Resolution Evidence Platform. They're an academic organization at the University of Edinburgh, primarily. Edinburgh Law School is Andrew Lang's platform, and it's Tim Epples too, even though he manages Peace Rep. And they are academics trying to study and research the ways in which conflict resolution happens. And they're part of a research consortium that includes all of these universities and includes an NGO like the World Peace Foundation and the Middle East Center at the London School of Economics. And this consortium works together to gather data, share projects, promote grants together. They do courses, and what's really interesting is they have a database of over 2,000 peace agreements that have been negotiated all over the world, whether they're peace agreements of major countries or whether they're peace agreements of local actors. And they do deep case studies of those. They're funded by the UK, and they work with the Foreign Office, and they sponsor these national dialogues. But what I really think is interesting about what they do is how important it is that you not rely on national databases and national official political organs descriptions of what has happened, but you need to go local and talk to the local community organizations and to local people. And often the story they tell is very different than the official story you get from governments. In their mediation work, you have to start at the beginning planning long-term sustainability. As we'll see in the case of Belfast, it's not enough just to try to stop hostilities. And here too, they said, so far the global north has dominated this work, but that is changing. This idea of how peace studies and the conflict resolution process works is also part of what they do at the London School of Economics. And what's interesting is they have a very different view than the Edinburgh group has. They work entirely on track 3, that is in community-based organizations. They have this word civicness, which is the restoration of a sense of civic identity in groups and the importance of social cohesion, which conflict often breaks apart. They say we need to understand that and I think this is true even of the kind of mediation perhaps that many of you do, that it's not a simple negotiation over a simple case in many cases, and certainly in the kinds of work they do, but it's always a polycrisis. There's always multiple things happening at the same time. It's kind of like, I spent my whole life teaching in medical schools, and you have the presenting symptoms of a disease and the underlying cause of a disease. And it's the same thing here. People come with a particular problem that they want you to solve, or they describe conflict in a certain way. But just a small scratch of the surface shows all kinds of other dynamics going on, and you're not going to solve the problem of these kinds of disputes if you simply solve the presenting problem, the presenting dispute. You need to dig underneath to the other kinds of crises that are going on. They're very interested in the idea of conflict on a war or conflict between armed conflict between groups or warlords, which they saw primarily as competitions, not just for revenue, but for resources. And the most interesting thing they talked about at great length is you think something like conflict resolution or peace treaties are the solution to problems. And their point is they're often not. So for example, they gave me an example of 2 warlords who were fighting, and the government asked them to come in and see if they could possibly help facilitate peace between the warlords, which they did. But they pointed out what that actually meant was the warlords finally discovered that it was much to their advantage to stop fighting with each other over resources and instead parse them out and say, okay, here's your area that you dominate, and here are the things that you get to control, and here's our area and our dominate, and the things we get to control. And the government was thrilled because the warlords stopped fighting. But in fact, in the view of the people doing the intervention, they just basically solidified the warlords' power over drug. They split up who got to market which kinds of drugs. They got to split up where their armies' boundaries were. And so the overt presenting hostilities ceased, but the underlying problem of warlords controlling organized crime in that region was actually enhanced by the conflict resolution process rather than resolved by that process. They too focus on peace agreements. They're part of Peace Rep. And their belief is that you often need to bypass governments. The governments aren't themselves that responsive to citizenry. They have other issues that primarily dominate their interests, and that it really takes more local organizations and local political groups to resolve the kinds of conflicts that are below track one conflicts. And now I want to talk about Belfast, by far the most fascinating place that I went to. That is Gary Mason, a remarkable man who is a Methodist minister and very involved in the resolution of conflict in Northern Ireland. The two largest Protestant paramilitary groups disarmed at his church under his sort of supervision. And I'm going to talk about Belfast for a minute because I think it's a perfect example of this idea of presenting problem versus underlying crisis. I asked Gary at what point, what do you think is the one thing that could most help solve the problems in Northern Ireland? And he said, amnesia. He said, there is a tyranny of memory here. Long after an event, the grudge still endures. And I'm going to give you an extraordinary example of that in a moment. What's interesting about Northern Ireland is that 26 years ago, 1999, yes, 26 years ago now, the Good Friday Accord was signed. And so since then, there has been very little violence between the Catholics and the Protestants, which is a remarkable thing when you think back in the 80s and 90s where bombs were going off in grocery stores and children were being killed, and both sides were militarily aggressive against the other sides, whatever your view is on who was worse at that. And so this is called a negative peace because even though hostilities have stopped, the two sides are just as opposed to each other, just as hostile to each other as they were before. And I'll show you that in a second. Though, sure, wars about identity and land and resources, religion and nationalism are powerful players that frame that dispute in ways that make it much, much more difficult to resolve. In fact, what's interesting about Belfast was it wasn't the political system that solved that problem. The people had finally had enough, and the communities forced their political leaders to create the Good Friday Accords. And Gary said he thinks it's going to take 50 years. We're about halfway through that now, 50 years to make real progress on this. So here is the signing of the Good Friday Agreement in 1999. Some things were in that Good Friday Agreement included the idea that there are gates between communities. Gary is standing in front of one of those gates on the right, and there are also fences along walls between the communities. The Good Friday Accord said those fences and gates will come down. That was part of what was agreed upon. In 2025, there are more fences and gates than there were when the Good Friday Accord was signed. The Good Friday Accord said schools will be integrated, and what integrated schools mean in Northern Ireland is Protestants and Catholics learning together. 26 years later, 7% of the schools are integrated. So the Good Friday Accords, were signed. They stopped the hostility, but those positive parts of it, the sustainability parts, the moving forward parts, were simply never accomplished. There are pockets of it. Habitat for Humanity is established, a Protestant and Catholic joint program of building houses. Gary himself runs a school that includes both Protestants and Catholics. There are pockets of it, but as a nation, that has not happened. And you see that when you drive through the community of Belfast. So on the Protestant side, these are the kinds of things that you see. A lot of posters and buildings that show the people that were killed by IRA bombs. By coincidence, we got there July 11th, not knowing that July 12th was basically the Protestant community's July 4th. It was the day that they celebrate their history, if you can call it that. We stayed at the Europa Hotel that proudly calls itself the most bombed hotel in Europe. And right down the street from it, Gary told us to go look at this. Can you see that, my cursor there, Scott? Can you see it? So this.
Yes, yes, we can.
Yes. Okay, so this was right down the street from my hotel. It's a 90-foot tower made entirely of pallets, wooden pallets. At the top, they've stuck a couple of Irish flags. On it were pictures, you can't really see them, of Irish leaders, also Palestinian flags. There's a very big split between the Catholics supporting the Palestinians, the PLO trained the IRA, and the Protestants, as you see in the lower right here, very much on Israel's side, as you see the flag in the upper left here. So they built this pallet with all of the pictures of Irish leaders and Irish flags. And then down here at midnight, they set it on fire to inaugurate July 11th. So they inaugurated their day of celebration of Protestant history by burning the Irish flag and Irish leaders' profiles. Then here, they had parades all over Belfast. You couldn't find Irish people on July 12th in Belfast. They just stayed home. And this parade, I don't have time to tell you all about it. I'll just tell you it was very surreal because it was hundreds of these troops coming by, drum corps and flute corps. Every single one had drum corps and flute corps playing the same 6 or 7 songs. But to just give you a sense of what Gary was talking about when he said amnesia and that grudges last, the purpose of these parades was to celebrate the great Protestant victory over the Catholics of 1690. Right? So, over 300 years later, their parades are still celebrating that victory from 300 years ago. Gives you a sense of how intractable this dispute is. Then the same thing on the Catholic side. You go through the Catholic neighborhoods, and it's a little bit, if you look in the upper right here, it's a little bit more like, heroic Soviet statuary and things. It's the great Irish leaders who stood up to the Protestant oppressors. And of course, you get a lot of this interesting Palestinian solidarity stuff. Picture of the IRA colors grasping hands with the PLO colors. I did that opposite way. You have these pictures. This is supposed to be Israeli soldiers standing over dead Palestinian bodies, the solidarity of Ireland, Palestine, and African liberation groups. So they see their liberation from oppressive Britain as analogous to other oppressed groups like Palestinians and certain African groups, and that is shown all over Belfast. So what's so interesting about Belfast is in many of the conflict resolution disputes, it's at this level, it's one country against another country. In Belfast and Rwanda, they're internal. And you see the stark contrast between the two. Belfast, there has been no resolution of virtually any kind. They've just stopped the fighting. Rwanda with its Gichichi courts. If you speak to a Rwandan today, I don't know how many of you have been there. Most of them, if you ask them before the conflict who they were, the first thing they'd say is they were a Tutsi or a Hutu. Now, if you ask them, they'll say they're a Rwandan. It's a real kind of attempt to try to move the country past the incredible hostilities of the past and this extraordinary genocide of 800,000 people. It's amazing that they're willing to do that at all. It doesn't hurt that they have a strong man right now telling them to do it. But none of that is happening really in Northern Ireland, certainly not the same way. So, really fascinating example of contrasts between those two societies. All right, now I'm going to turn back to what I'm trying to do here in Atlanta, tell you a little bit about PACT and the larger vision here, and then I'd love to hear some questions and responses. So when I got to Atlanta 17 years ago, I was very excited about the fact that I thought, this was the city of the Carter Center and the King Center. The Center of Civil and Human Rights had just been put up and was just starting out. I thought, we have Martin Luther King and C.T. Vivian and John Lewis. This was going to be a place where we really had ongoing and very public discussions of human rights and peace and conflict resolution. And it happens here and there, but it really wasn't. Atlanta had never forged an identity as a city that does that kind of work. If you go and you talk to Detroit or Boston and say, tell me about Atlanta, they'll almost always mention Martin Luther King, but they don't see Atlanta as the Geneva of the United States, for example. So that was also something that I was always interested in, and I'll tell you about that. I have what I call the three-ring model of PACT that I'm trying to build. At the center is the Emory Center for Peace Building and Conflict Transformation that we're building at Emory, and that we are, I've contacted other major universities in our region to talk about how we can work together. This is very much, hopefully, a collaborative project at the university level. Next year, we're going to have a peace house at Atlanta that'll house 30 to 40 students interested in peace and conflict resolution. We're going to be training undergraduates and graduates in conflict resolution skills. And the PACT will certainly do scholarship, the kind of scholarship that universities do. I'll show you some examples. We'll do both education and outreach, but also I want us to be an applied center the way my Center for Ethics was, and actually have skilled mediators and conflict resolution services. And I welcome any of you who want to get in touch and talk about that and possibilities of cooperating and collaborating with PACT to do so. As I went around Europe and I talked to these centers, they would tell me of the wonderful work they were doing in Kuala Lumpur and Bogota and places like that. And I would always say to them, so what do you do in Switzerland? What do you do in Norway? What do you do in your own country? And the answers were almost always very little. All of these organizations were focused outward. And I talked to them, I said, well, I'm thinking of starting my center with a primary focus domestically before we move out internationally. And almost to a person, almost to a group, they said, we really need to better develop domestic conflict resolution literature, research, studies. There's an enormous literature on conflict resolution diplomatically and internationally, but it's really not there so much on domestic issues. Because Emory partners with the Carter Center, and the Carter Center has an international conflict resolution team, we're going to start PACT focus on domestic conflict, and then we'll have a nice continuum, a nice spectrum from domestic work at PACT through the international work of the Carter Center. Interesting things that we're probably going to start with in terms of our research. The question of narrative and memory. One of the things that is interesting to hear over and over again from people who do this work is everybody has a story, and those stories structure how they think about peace and conflict. You go to Belfast and you hear the Catholics tell the story of the history of that country very, very differently than the way the Protestants tell it. The Israelis tell it differently than the Palestinians tell it. um, trying to understand the nature of cultural narrative. And by the way, that's true even in local disputes. In disputes like the Atlanta Police Training Center or the water dispute between Georgia and Florida, if you listen to the narratives of those groups in conflict, you'll hear very different stories of what the conflict's really about and what the motivations of the actors are. Certainly, based in Atlanta, the discussion of race and other identity politics and the conflicts that they create has to be part of what we do. Emory has great expertise there. We're going to include an element of medicine. I am the Raymond F. Shinazi Professor of Jewish Bioethics. Ray Shinazi, as many of you might know, is one of the great living virologists. He's the man who basically cured AIDS. He created antiretrovirals. He's just one of the 3 people who cured hepatitis C. And he gave us a grant and he said, I want you to find a way to include medicine and medical issues in this. And as I talk to groups in Europe about it, they say, we deal with health issues all the time, whether it's environmental, whether it's, I met with a man named Ken Hyatt, who used to be Undersecretary of Commerce under Obama. And he now has started an NGO because he is a conflict resolution specialist, even though he was Undersecretary of Commerce. And he said to me that he thinks the single major reason that conflict intervention fails at that level is because people don't understand the impact of collective trauma. And he wants his NGO to study what does collective trauma mean for a population. And then looking at methodologies. Another thing that's really interesting is AI in conflict resolution. When I asked people internationally, what do you think are the up and coming issues? AI and conflict came up a lot. So I did a little bit of research on it. It is pretty remarkable that there's a literature in the business literature. There's a lot about using AI to solve regional conflicts, to solve war, and also the conflict of AI replacing human beings. So AI and conflict resolution is a very interesting area. I spent the last 6 years of my career at the Center for Ethics doing the ethics of AI. So I'm very interested in that issue. And then finally, and for what PACT is going to do, the next circle in the 3-ring circle is the creation of the Atlanta Coalition that hopefully will bring Atlanta into a branding as an international city of peace. So this second circle, I've brought together the King Center, the Carter Center, the Center for Civil and Human Rights, Andrew Young, Martin Luther King III, many of these other players, and included things like the Woodruff Art Center, as well as other universities, to try to create an Atlanta coalition. And that is a group that cares about these kinds of issues, that does conflict resolution, that works for peace building, both locally, regionally, and nationally and internationally. Because Atlanta has and Georgia has an absolutely unique set of resources. There's no other city in the world with 2 Nobel Peace Prize winning institutes. Our iconic institution, we tried to build a Center for Civil and Human Rights. If we can bring them together with other NGOs, corporate partners, and academic institutions, and actually structure and organize these groups together, we will have a kind of resource that no other city in the world could have. So I've been working to do that. It's a slow process, but there's been nothing but positive responses from all of those institutions. So I do think it's achievable. The 4 leading institutions that I hoped would be receptive to this have all agreed to be part of a coalition. There's still a lot of work, a lot of things to work out there, but the intention is good on all those sides. And then finally, the last ring of this is Atlanta as a city of peace. Of the 19 cities I visited in Europe, at least 10 of them, maybe 12 of them, call themselves cities of peace. And if you think about it, Oslo, Helsinki, Basel, Zurich, Geneva, The Hague, there's Amsterdam, there's so many cities that do this kind of work in Europe. Many of them call themselves very explicitly cities of peace, even though Geneva tries to say it's the real city of peace. So you've got a robust peace industrial complex, you've got competition there, you've got strong identification of these cities in Europe, and yet we don't have a single city in the United States that has captured that identity. And so my contention is Atlanta should be that city, Georgia should be that state. I met with the mayor on Monday, pitched this, the Governor Kemp, I met with Governor Kemp, with John Ossoff, and I met with the mayor on Monday, and all of them are receptive to the idea. The question is, can Atlanta really build that brand? It has tried many times in the past and failed, but I believe it's failed because they always tried to do it top down. They just came to Atlanta and said, we should declare ourselves the city of peace. And I'm suggesting we build it bottom up, build PACT, build the Atlanta Coalition, create the infrastructures, and then talk about Atlanta as a city of peace. So this is the project that I've been doing. I'm on a 3-year mission to get these 3 levels done. Really appreciate the opportunity to tell you about them and would love to answer any questions you might have or talk about this with you all.
Hi, Paul. Wow, I think it's especially true with an audience like this, full of folks that believe in mediation and conflict resolution, that your talk is inspiring. How proud we would be as Georgians to see what you can accomplish with PAC and with the coalition. So I'm sure I'm not saying anything out of line from the folks that are attending today, that this is really what we needed to hear and wanted to hear. I have a bunch of questions for you. Let me start just globally with the curiosity. You mentioned and identified so many organizations in Europe and internationally that are involved with peace. At the same time, there's so many darn conflicts going on in the world. How are these organizations not stepping over each other, or how are they coordinating the effort at conflict resolution internationally?
That's a great question. I ask that question a lot. And so it's an interesting field. So these organizations need money to keep operating. And interestingly, there is money for many kinds of conflict, and then there's no money for other kinds of conflict. And so what ends up happening is these organizations compete for those conflicts where there is money, whether that money comes from governments, whether that money comes from international organizations, whether that money comes from the UN. There are certain conflicts that, for one reason or another, either because of national or international attention, money becomes available, and they compete fiercely for those contracts. And that's where the competition comes in. But as every single one of them practically said to me, there are conflicts all over the world, and we do some pro bono work, but there are far more conflicts than there are organizations available to help mediate conflicts. And that's true, especially if you think of conflict not just in these sort of international terms they think of it, but in regional terms. So when I was director of the Center for Ethics, the Center for Ethics, which nowhere on our website talks about mediation in any way, we would get probably 5 calls a year from groups saying, do you do mediation? We have a conflict and we don't know who to call. We can't afford what in their mind were, the wealthy, the expensive lawyers that do this kind of work. Despite the fact that, and I would often say to them, there's a lot of pro bono work being done out there. There isn't in the minds of most people what the resources that they have when they're in conflict. And so when you really begin to look around and see where there are conflicts in your communities, in your regions, they're everywhere. And then when you multiply that by all of the regions, all of the states, all of the countries, all of the organizations, there is far more conflict that could use sort of sober mediation services than there are resources for it. The problem is the vast majority of them are under-resourced. They can't really pay for those kinds of services at any high level. So, our center, hopefully, since we're an academically based center and we don't have to make money, part of what I want us to do is do some mediation pro bono to train students and those kinds of things. And that's, by the way, what a lot of the master's programs do. I'll tell you one other quick interesting thing that's related to your topic, to your question. Rotary Club, one of the 7 areas that it focuses on is peace. They have 7 areas that they fund. And one of them is peace. There are 7 Rotary Peace Centers internationally, but all of them were based on master's programs. That is, the Rotary philosophy was, let's fund the next generation of leaders. So I spoke to National Rotary and I basically said, I have a different vision of what I'm trying to build here. I want to tell you about it. Maybe it might be something you're interested in. And the response I got was, we have recently decided to stop funding master's programs, and we are going to start facilitating the creation of what they called regional peace hubs. And they said, what you're describing is a regional peace hub. So there's a good chance, if everything works out, and this is, just a pie in the sky right now, but it's very possible that Atlanta will be the first Rotary regional peace hub. But I'm telling you this not to say that so much, but to say they also saw this problem. That is, National Rotary, after working in peace for so many years, realized that, creating leaders who are going to go off and be diplomats was certainly helpful and helping at that track 1 level, but that these kinds of regional, underfunded, problematic disputes, take the, I like to use the example of the police training academy here in Atlanta because most people in Georgia know about it. It was so controversial. It was, there was sit-ins in the forest. The police group, had that unfortunate incident where they killed one of the protesters, and they were charged with RICO and all of that. I mean, that was a dispute where conflict resolution professionals did not get involved. And so that conflict went on and on and on. And I happened to meet the president of the police foundation that was funding the center. And I said to him, have you had conversations with the protesters? Have you had, no, they had never spoken to each other. So this conflict went on in kind of a parallel way. And I don't want to get, it's not about the police academy. It's just an example of how these kinds of disputes happen. And if Atlanta was a regional peace hub, if all of these organizations, Carter Center, King Center, if all of them were together in a coordinated way, if we were known as a place that had these extraordinary resources for intervening in conflict, I believe that there would have been a collective decision to bring that resource into a dispute like that. But because it's so scattered here, because there's no centralization of those, it never happened. So that's what I mean by trying to create more regional resources for conflict.
Well, that actually leads into the next question we have from a participant who said he's a lieutenant with the local police department, commander of their crisis negotiation team, and a registered neutral in Georgia. Does PAC work with police agencies in crisis conflict resolution for their services?
So PAC doesn't do anything yet. We're building it right now, but it absolutely will. And in fact, when I spoke to, I'm sorry, I forget his name, the man who was the head of the police foundation. It was quite a while ago now, but I had talked to him about that. I said, when we're ready, when we're established, right now we're still building PAC. It doesn't exist yet. But when we're established, I said, I really want to find out who the right people are, in the police infrastructure of our city and state, because I think it's crucially important that not just that we work with the police to be a resource for conflict resolution, but because the police have a unique experience with and expertise in certain kinds of conflict, and that expertise is crucial if you're going to really train people on how to intervene and mediate. The police experience is a really valuable one to include.
So another comment from one of the participants, and obviously, again, you're speaking to the choir in many ways with regard to this topic. Have you heard about AVP, something called Alternatives to Violence Project, and HEROC, healing and rebuilding our communities? Because the question is, would you consider collaborating with them on peace and conflict resolution training? So you have a lot of interested groups out there.
Yeah, that is the thing. In fact, I have students working now doing research. There are so many more groups that do this than you originally think when you get into this. And there again, there isn't enough coordination, not just locally. I'll get back to that specific question. When I went and visited centers around the United States, so I'm a bioethicist. We have a national bioethics meeting. Almost all the bioethicists come to it. I was president of our national organization. I knew almost every bioethicist in the United States. It's a relatively small community. When I said to the, people at these peace centers, what national meetings do you go to? Where do all the peace, organizations in the United States and all the academic institutions that do this get together? There isn't one. There's peace studies, which is very academic, and it just, it looks at research and things, but peace activists, the applied peace people don't come to that, right? There's no central place where we have this conversation in the United States. And I think that that's a shame. It's something that we really need. And the same thing locally. As I've been doing this, I was away for a year, so I've really only been working on this in Atlanta since July, so just for 3 or 4 months. And by the way, have had to spend a lot of that time fundraising because the economic situation changed drastically while I was gone, for higher education. So the resources to fund this center at Emory are not what they were when I left. But what I've discovered is lots and lots of organizations in Atlanta that in one way or another in the Venn diagram overlap around peace or conflict resolution or mediation or difficult conversations, which for some people are different. Like Braver Angels is about trying to get the political right and the political left to have conversations. The Koch brothers started Standalone. It's not in Atlanta, it's in Texas, but that's also just to get the political right and the political left talking. Is that a conflict resolution organization? Does that get included in, so there are lots and lots of organizations that either do this specifically or are somewhere on the periphery of this. But they themselves don't necessarily talk to each other or know about each other. So whoever asked that question, it's really easy to find me, P. Walpe, first initial last name at Emory. Please email me. We're trying to get a sort of comprehensive list of organizations in Atlanta that do this kind of work. And then at some point in the future, I hope, have a meeting where we invite everybody to come and perhaps begin the process of finding a way for us all to recognize each other and work together.
And I guess we have time for one more question, and maybe this is a bit, maybe too big of a question. You've identified religious issues that divide countries with regard to conflict. What are you learning with regard to economic divisions between groups or countries that create conflict? Is there an economic solution that groups are working on to bridge the gap?
Yeah, you're right. It is a big question. And the answer is all the way across the spectrum. That is, some places are and some places aren't. It's often about economics. It's often more poorly resourced people against higher resourced, groups. That is how it's perceived often in Belfast. The Catholics think of themselves as poor against the, wealthier Protestants. So there's no question that resources part of conflict in many cases, if not most cases. That is, fights are often about resources. They can be purely ideological or purely religious, but they're almost always about some set of resources that are being fought over, or some resentment about resources that aren't being shared in the views of one side or the other. So economic solutions to these broader conflicts has to be part of it, because those are the structural issues underlying conflicts that don't go away. And if you don't deal with, I mean, it's what I was trying to say earlier. If you deal with the presenting symptoms, but not the underlying disease, then those symptoms come back up. And so if you can't get underneath whatever the conflict was ostensibly about and talk about what really generated this conflict, which is often economic inequality, then you really haven't solved you've only solved the problem today. And these conflicts are just going to come back up later.
In line with that, the question is about when you're working to create conflict resolution, how do you ensure that relevant parties are included in the process, the relevant stakeholders
Right.
sitting at the table?
So there are methodologies that try to get at that. So for example, talking about cross-disciplinary work, at Emory, we have a guy named Jim Lavery. He's really well known in the field of public health. He created something called broker dialogue. Because think about a public health intervention. You go to some country and you want to help them, vaccinate everybody or do some other kind of public health intervention, whatever it might be. You've got local, regional, and state health groups. You've got local and sort of broadly country religious groups. You've got tribal leaders. You've got community elders. You've got all of these groups. It can be 30 or 40 different groups. About 80% of public health interventions fail, in part because groups are fighting over them or not allowing those public health officials in or things like that. And so what Jim Lavery did was he created this thing called broker dialogue, whose entire purpose is to get all of the stakeholders together and to solve all of their objections and problems in a structured way before you try to implement the public health thing. And I think I think the same philosophy is true. And I think, sophisticated conflict resolution people in these organizations understand this, that you have to get all the stakeholders together. You have to do the work of solving the preliminary problems, get them in the room, some of which are solvable. And getting people into a room as far along in the process as possible before the intervention actually starts is often a really wise thing to do, so you can really focus on the issues of importance and not get distracted by peripheral or collateral or trivial issues that they care about, and people always have those. Like so it's crucially important, and I think most people understand this, to get all the stakeholders together. If you have major stakeholders left out, then you haven't really solved the problem.
Well, Paul, I want to really thank you again for taking the time to present to this group. I think you have a lot of folks that are in your corner as to what you're doing with PAC and what we can accomplish as a city and as a state for peace and conflict resolution. So you were worth the wait. Thank you for sorry for always trying to get you to participate, and I really appreciate you taking the time to do this. Thank you from everybody, and hopefully we'll see you soon.
My pleasure. Please feel free to get in touch.
Thank you.
Bye, everyone.
Well, that truly gave the international part of our International Conflict Resolution Day element today, and we're going to continue on with our next speaker. Rhonda, how are you this morning?
Good. I really enjoyed that talk.
That was a fun session. He's really interesting what he's doing. Well, I want to thank you for joining us, Rhonda, and welcome you to our International Conflict Resolution Day. And I'm going to get a chance to introduce you to the group and then turn it over to you. So Rhonda Muir is the founder and principal of Law People Management, LLC, a leading authority on lawyer personalities in the application of behavioral science to the practice of law. Rhonda draws from years of experience as a lawyer in New York big law, as inside counsel for a privately held conglomerate in Paris, France, and as vice president of the CPR International Institute for Conflict Prevention and Resolution. She's a frequent speaker, an award-winning author, and publishes lawpeopleblog.com, I think that you'll tell us about during your program, and also has a best-selling book, Beyond Smart, Lawyering with Emotional Intelligence, published by the American Bar Association, with her recently released second edition, which she'll tell us about today. So Rhonda, thank you for taking the time to join us. We have a group of over 200 attendees today, which is a record, all waiting to hear what you have to say about lawyer intelligence. I think we're going to be all interested in hearing that. So thanks for joining us.
Thanks, Scott. We're going to go from the worldwide international arena down to the internal arena. So a big change of location here. I'm going to pick up my slides and start from there. I'm very happy to be here talking about Elliot. So we've learned a lot about emotions. One of the things, slide 5, is that emotions radiate. I said to you that within a half a second, your amygdala responds to an emotional trigger. In that half a second, neurochemicals start radiating throughout your own body, coursing through your body. It takes 6 seconds for that to completely encompass every cell of your body, to have those neurochemicals operating there. They radiate in a way that the woman who, the researcher at the National Institute of Mental Health, Dr. Candace Pert, called this that we vibrate like a tuning fork. These emotions not only radiate outward, but influence other people and their emotions, as well as their emotions influencing us. Whether we intend to or not, it's very important. That 6 seconds, there's actually an emotional intelligence organization called 6seconds.org, which is based on that understanding that it takes 6 seconds for the entire body to be saturated with these neurochemicals. It's often sometimes called an amygdala hijack. Basically means during this process, it's very hard to engage your prefrontal cortex. That they're the hijack is that your whole body is sort of consumed or affected by these neurochemicals. This is the basis of something called emotional intelligence. A Yale study sort of illustrates this very succinctly. If you take 2 people who don't know each other and put them in a room for 2 minutes, they will come out with essentially the same emotional state. And that's based on this idea of the radiation of emotions. The other thing that was interesting about that study, just for everyone, is that factors that made whose emotions prevailed in those 2 minutes was hierarchy, who was perceived to be higher on the hierarchy, and who was most expressive. So in leadership, it becomes very important because we talk about leaders as being the emotional thermostat for an organization. So if they are hierarchical and expressive, they have the ability to actually influence the emotions of a group. Next slide. So this saturation actually permeates our bodies and changes our physical experience. This is a heat map that was done of various emotions. And it's just sort of interesting because things like butterflies in our stomachs or hot-headed or cold feet actually relate to physiological experiences associated with emotions. And if you're good at this, you can actually learn what your emotion is by how you feel physically. Next slide. Important to us as lawyers is that emotions color our judgment. How steep is this hill? It depends. How do you feel? If you have a sad or negative feeling, it's going to look steeper. It's going to look higher. It's going to look further. If you have a more positive feeling, it will be the opposite. It's not just this kind of perception. It's perception of sound. It sounds stronger, harsher if you have a negative feeling. The smell will change depending on how your mood is. Spiciness of food, even attractiveness of other people can change depending on your mood. So our emotions color our judgment. Doctors, for example, who are in a good mood, reach the right diagnosis 20% faster than doctors who are in a negative mood. The best study on this was a Yale study done about teachers. They were able to manipulate the mood of college teachers who were reading essays to grade them. And when they were in a negative mood, they read them and graded them. And quite a bit of time later, when they were in a positive mood, they also read them and graded them. The difference was that when they were in a good mood, the letter grades on the same essay were 1.5 letters higher than they were when they were in a negative mood. And particularly telling is that 85% of those teachers said their moods, their emotions did not affect their grading, which of course they did. Another very important study was done by judges in Israel, again, closer to our experience, where they were hearing parole petitions, and they did this in 4 2-hour sessions a day. And after each 2-hour session, they had a break and something to eat, etc. But there were 8 judges. The results for all 8 judges were the same, which is that there was an average approval rate of 35% for the day, but in each 2-hour session, started at very high approval rate, close to 100% in some cases. By the end of the 2 hours, it was much lower. So that trend continued during that day. So by the last 2-hour session, they were proving 0. At the end of they were proving 0. Where at the beginning of the day, as much as 100%. And these went at 6 minutes a clip. These were not ordered in any particular order. It just showed very clearly how much their mood, and they were obviously tested on all this. They got hungry, they got distracted, they got bored, they got involved in thinking about other things. So our mood has a huge impact, whether we realize or not, whether we know that or not, it still has a huge impact. Next slide. It also impacts our emotions, impact our performance and our profits. This is called the Yerkes-Dodson curve, which you may have seen. It talks about stress, but stress is an emotional state. So we have to have a certain amount of stress to get out of bed in the morning. It goes up to an optimum level. And the optimum place, before you go over into exhaustion, breakdown, overload, is, whoops, something's happening on my screen there. A very small area. So it's very important to be able to manage the stress in that area. You want to have enough stress to get optimal performance, but you don't want to stress too much or you'll not be in the optimal stage. And this requires very good emotional intelligence. It requires you being able to manage your stress and your emotional reactions to stay in that area. It's called flow, technically, in psychology stuff. This also relates to our profitability. Our emotions impact our profitability. And the best study on that was done of a very large accounting firm. They took the US partners who had been working for at least 10 years, who had the highest EI, and compared them to the other partners who had worked at least 10 years. These are accountants. And the profitability of the high EI group was 5 times greater than the average group. We've seen this in financial services. We've seen this in a number. There has not been done on lawyers extensively. There's some, certainly we have rainmakers that seem to have a higher EI, but it's not as decisive as some of these other studies have been. Next slide. Thank you, whoever's doing this for me. So we also know that emotions affect us physically. If you have good emotional intelligence, you're more likely to have a good immune system. You're more likely to have longer telomeres, which part of our body, which indicates longevity of life. You're also more likely to have less emotional distress. And emotional distress is an issue of emotions, obviously. This was a study done, probably the most extensive one, about 15,000 lawyers. The ABA and Hazleton Clinic did this together. This is what they found. And we can go through these, but you can see the rates. What you may not know is that these are 5 to 8 times higher than the general population. So there's clinical anxiety, very high, clinical stress, very high, substance abuse, very high, depression, for example, is 6 times higher than in the general population, suicidal thoughts and suicide. To talk about the suicide part, young males in the United States are the highest risk of suicide. Male lawyers at 2 times that risk, and climbing. So their conclusion at the end of this study, which was very extensive, was that attorney impairment is profound and far-reaching. And this is impairment because of emotional distress, unable to manage these very distressful emotional situations. You think about who we have on the front lines with our clients in mediation, negotiation, that there's a pretty good likelihood that these people are distressed and they're handling, clients bet the farm type of issues. So this is a very disturbing result. I don't know, Scott, if there's someone who has questions about what we have done so far, I don't see those, but
Well, I can call them out if you want to take it as you're presenting or save it to the end. I did have a really interesting question come up. Does the virtual process, I assume they're talking about Zoom and non direct physical contact, change the radiation of emotion?
That's a really interesting question. I don't think there's been any study on that yet. There has been a study that you don't get as good relationship and opportunity to form and build relationships virtually. I mean, there's some things they studied it during COVID, obviously. Some things that they recommend, face to face, at least 15 minutes every day. I mean, I don't know who can do this, but with the people you're managing to try to build that same type of relationship. But it's a very good question. The research has not been done. I wish it had been. Maybe it's being worked on now.
Okay. And
But
while you're
certainly-
taking a quick question, I'll ask about your book. The question is, does your book discuss and cite to research, and are the slides taken from the book? So guide us a little bit more about what the book will tell us on this topic, if you can, for a quick sec.
Well, the book is much more extensive, obviously. It covers all sorts of things about how individually to raise your emotional intelligence. It talks about AI quite a bit because that's sort of it talks about the COVID results that have come in. Talks about different types of litigators, negotiators, judges. There's a big section on judges and their emotional health. And so it covers a whole lot. I'm trying to hit highlights here for you. Was there a second part to that question?
Nope, but I still invite folks, since you're willing to take questions during your program, to put them in the chat, and I will, when you're ready to take a break, I'll ask you more questions.
Okay, so now we're going to go into the part about lawyers and emotional intelligence, which we started to hit there. So next slide. Okay. We know that lawyers are smart. Once you hit the next point. Yeah, there's our IQ. That's called 2 standard deviations above average, which is 100. We are used to acing all those assessments, right? Now let's hit the slide again. That's our emotional intelligence. Average, I'm not talking about anybody in particular. That's our average emotional intelligence, which is 1 standard deviation below again, the general population of 100. It's lower than the average doctors, surgeons, accountants, and certainly the general public, which of course means that your witness, your staff, your public even other professionals, may very well have a higher emotional intelligence rating than you do. Which is something hard for us to deal with. I mean, a lot of lawyers don't want to hear this, but that's certainly the data we have. All right, next slide. If you simplify a lot of the emotional intelligence research and theories, there's like 3 major theories. If you simplify that, you come up with these 4 major skills. The first one is emotional perception. They work on a pyramid basis. The first one at the bottom is emotional perception. That means, can you perceive your own and other emotions? And the research says if you're good at one, you're probably good at the other, your own versus others. So that's, can you identify the emotion? Do you know that what you're feeling is anger, or do you think it's irritability, or what they are feeling, do you think is shame, or do you think it's guilt? Or so your ability to actually perceive emotions. The next part of the pyramid is emotional empathy. There's different types of empathy. This is emotional empathy. This is the one that says, I know how you feel. And when we go back to that description of the brain, you can't say, I know how you feel, unless you can identify their emotion and your experiences and tap into that. I do know how you feel. That's emotional empathy. So it's reliant on emotional perception. Then emotional understanding is, do you understand how emotions progress? Do you understand what they're made of? Because there are very few pure emotions. Like disgust is anger and hate. So there's very, very few emotions that are just a singular emotion. Do you understand the complexity of the emotion, and do you understand how those emotions might progress over time? People with a high emotional understanding quotient are very good at being predictive. There's something that's called the oracle effect, which means that if you understand emotions well, you can predict what's going to happen over time. And then there's emotional management. This is very important because it means, can you regulate your own emotions? Can you manage your own, and can you manage those of others? Can you manage the interplay with other people? There was a couple of things that came up recently. I read the book, Isaacson's book about Elon Musk, and depending on what you think of him, I found this sort of interesting that he had $1 million McLaren and he was on his way to get a critical investor and had a major accident that basically totaled the car he walked away from. And then he walked into that immediately, into that meeting about 20 minutes late, and secured the investment. So there are a lot of things that could be going through you emotionally after something like that, whatever you think of Elon, or how atypical this might be of his behavior. Clearly, he was able to emotionally manage himself to go into that situation and be successful. So, but let's look at this from a mediation negotiation standpoint. Emotional perception, we have, first of all, perception is not just hearing or seeing. I mean, we understand that 10% of communication is words. The rest of it is expression, it's body language, it's cadence, it's tone. So perception is a complex thing, what you perceive. And we know that from research that if you have high emotional perception, you're more likely to successfully analyze the issues, which makes sense, right? But also there's an increase in the amount of money that is gained by the seller who has high emotional perception. Interesting factoid. On emotional empathy, we know from research that those with high emotional empathy are able to improve the working relationships and negotiation or mediation. They have better brainstorming abilities and produce higher trust, more creative. And at the end, the opponent not only feels positively about this negotiation and the outcome, irrespective of the financial terms. This is what the study found. They also like the other negotiators and prefer to negotiate with that person in the future. on those with high emotional understanding skills, as I said, are better able to understand and predict the progression of the emotions of the experience. That's that oracle effect. And on those high in emotional management skills, the study shows that they're better able to assess and offer, analyze the risk and the potential by consciously eliminating the emotions that are irrelevant or counterproductive. That's that Musk experience, that you can eliminate those, you can set them aside and only focus on those emotions that are relevant to the issues that you're discussing. There was an MRI study of someone who was in negotiation with someone who was offering them very little money on a very important deal. And it showed that there was an internal negotiation within that negotiator between his amygdala and his prefrontal cortex, that they were negotiating with themselves, essentially. The negotiation was, should they take the money, which was presumed to be too little, or just walk away. And the high emotional regulation people were able to choose to take the money in the circumstance where that's what the client wanted, rather than just walk away in annoyance. The problem with emotional management for many people. So from a gender standpoint, if you're interested, women tend to have a little higher emotional empathy, can bite them sometimes if they're not able to manage that. And men tend to have a little higher emotional management, which is understanding and management are both more analytical skills. The issue can be, though, too much suppression. If you sort of have this whack-a-mole attitude towards emotion that you're going to eliminate them in the moment, that's a problem because that's what we call emotional labor. And if you're doing too much emotional suppression, you can't think straight. So that's that issue. So of these four, what are lawyers? Why do we have such a bad score rating? Which are we not good at? Well, unfortunately, the one we're worst at, very clearly with all the studies, is actually the most important one, emotional perception. We get that wrong. We do not see it. We misrepresent what we feel or what we see, and it causes a lot of problems. This is what we call a garbage in, garbage out concept, because if you get emotional perception wrong, if you think what you're dealing with is shame, and what you're dealing with anger is actually anger, but you're going down the shame path. Oh, I know how you feel, and this is what happens when someone feels shamed, and then how to manage that. All the analysis is wrong because the perception is wrong. So we're going to go through just as real quick because I want to make sure we have time for everything. We're going to go through a few slides from a assessment, a quiz. It's called Reading Emotions in the Eyes. And this is truthfully done by Sacha Baron Cohen's psychologist cousin, Simon Baron Cohen, who is a psychologist at Cambridge University. It was developed 20 or 30 years ago. Is somewhat controversial for reasons that are not particularly relevant here, but it's gone through racial, gender, other sorts of circumstances to give us a pretty good reliability factor. And it's to judge how well you can read facial expressions. So let's go to the next slide. We're going to do 4 real quick. You should very quickly look through these 4 and say, which one is it? Because you don't want your prefrontal cortex working on this. You want your amygdala working on it. So what is this? Aghast, baffled, distrustful, or terrified? This is distrustful. See. Now the next one. Yeah, this is contented, apologetic, defiant, or curious. This is defiant. Next one. Ashamed, confident, joking, dispirited. Confident. Next one. Despondent, relieved, shy, or excited. Despondent. Now, these are not, I'm not trying to tell you that this is going to tell you where you stand on all this, but you can take this assessment. There's 36 questions. Lawyers don't do very well, in general, don't do very well on this. Most people are in this 80% correct, and lawyers are down in the 40% correct. But it's a useful exercise sometimes to actually see how you're doing on just this piece of emotional perception, recognizing it in other people. So I would like to take a real quick break again, if there's a question about lawyers and emotional intelligence very specifically before we go on to negotiation and mediation.
Well, you are getting lots of questions. Let me just ask this because I just failed that test on all four. So
Don't be bad. Don't feel bad about that. I went quick.
well,
And yeah.
is there, I mean, obviously people are looking to hire, you know, mediators and neutrals that obviously have high emotional intelligence. Is there a test? Is there a standard? I mean, how can we all figure out for ourselves, your attendees, what our emotional intelligence is?
The one I recommend as an assessment is the Mesquite, that's MSCEIT, which is the Mayer-Salovey-Caruso Emotional Intelligence Test. It's the only assessment that is abilities-based, which basically means it's like an SAT. It gives you a scenario and says what should happen or what's going to happen or how do you improve this situation. It's that kind of assessment. The rest of them are like, there's two others, and they're good for other reasons, I think, for some reasons. But the others tend to say, are you emotional intelligence? And, you know, us lawyers, we say, of course we are. So they're not quite as useful, I think, in trying to figure out your strengths and weaknesses. The Mesquite has several tests and subtests. There's even one of the tests that looks at how good you are at surveying emotions in the room, which is great for a litigator, you know, the jury or the judge. So that's the one I recommend, Mesquite. And you need to have someone professionally, in my opinion, you need to have someone professionally explain your results. It's not hard. I think it's 45, 50 questions, probably takes 45 minutes. And you can't, I've had lawyers try to like screenshot it and research it and come back that doesn't work. It's really, it's a good assessment in my opinion. So that there's also tons of quick assessments. There's something called the goodmood.com, I think. I could maybe look these up, but there's several free short assessments online. And you can always go through those too, because they at least will give you a hint.
So this question goes to that topic. Very interesting phrase of this question. So you discussed the extent that or can you discuss the extent that research says on cause and effect of emotional intelligence in lawyers? For example, are folks with low emotional intelligence more likely to become lawyers, or does the practice of law itself constitute reducing EI over time?
Well, let me answer three different steps. Yes, over law school, emotional intelligence goes down, unlike medical school, when emotional intelligence goes up. Secondly, Peter Salovey, the guy who did a lot of this research and became president of Yale, started out doing research on learned helplessness. And what he found just by accident was that people who were good at the LSAT tended to have a depressed mood, which he later indicated may very well mean they have lower regulation ability, emotional regulation ability. So what he was essentially saying is that we're sort of putting people into law schools that start out with emotional intelligence deficit in the regulation area. That was really interesting. Now, go back to the first part of your question, sorry.
Well, it's the question of, I guess, are people with low emotional intelligence the ones that go to law school and practice law, or is it the fact that the practice in law school then results in their lower
Well, so
emotional
it's
intelligence?
both. It's both. They are, we understand, more likely to have emotional regulation issues to start out with, and going to law school lowers their emotional intelligence. But the other thing I was going to say is that there is a little bit of a dispute within the theoretical community as to whether or not you are born with a particular emotional intelligence or it's fashioned over your lifetime. But and it's more towards fashioned. But everybody agrees that you can improve your emotions, not like IQ, which is sort of set. Everyone agrees that emotional intelligence is something that can improve and often does improve over time. So it's not a lost cause, not at all.
And then the next question that went with this, and I guess it would apply to lawyers, I don't know if you're going to touch on it later, is how do you connect the interplay between emotional intelligence and ethics?
I do whole programs on emotional intelligence and ethics. We have a lot of studies.
Can you talk a little bit about it for this group?
Yeah, so all of these factors, being able to perceive emotionally what's going on, being able to be empathic about it, being able to understand the emotional, all of that plays into ethical considerations. The studies clearly show that high emotional intelligence people are more able to withstand the temptations of being unethical. Now, part of this, in my opinion, is that high emotional intelligence lawyers are more likely to accurately perceive the situation. So let's go to like harassment, sexual harassment, which none of us condone. But is part of the reason of that harassment is because the lawyer involved doesn't correctly perceive what's going on. He or she thinks they're being encouraged or they're being flirted with or something like, there's the perception piece clearly impairs your ethical abilities. But it's apart from like that perception piece, there's very clear, most of it I think goes towards being able to emotionally reward yourself for doing the right thing. But like I said, that's a much longer conversation.
Yeah, I guess I'll let you continue and I'll save some of the questions as you wrap up.
Okay. So next slide. So the importance of emotions in a negotiation and mediation. We know that there are huge business advantages to having high emotional intelligence. I could go through a lot of better decision making, which we just talked about, better relationship building, better collaboration with colleagues, lower attrition, higher productivity, ability to retain clients, greater profits, higher team success. That's a big issue in law these days. Team, the most predictive element about what makes a team successful is its emotional intelligence, not its IQ. Google found that out. Better leadership, greater well-being and mental health. So lower liabilities and costs, lower malpractice costs, reduce conflict and better conflict management. Those assessment studies covers all of that. Next slide. So this is some things that have been said about emotions in negotiation and mediation. In a negotiation, particularly in a bitter dispute, feelings may be more important than talk. That's the getting to yes. It's like 20 years old probably, but it's sort of standard text. They got some pushback because feelings are more important than talk. That's what they got and they have since sort of updated that. But next point, most deals are 50% emotion and 50% economics. That's Felix Rohatyn. Next one. Negotiators, especially those trained in the law, often come to the table with no conscious awareness of their own emotions or ignore or exclude emotions to avoid feeling discomfort, especially those trained in the law. So we know we have reason to believe, based on some experts in the field, that negotiation mediation has to consider emotions, that that's a major part of what's going on. So next slide. So these are some of the in negotiation media. These are some of the studies that have come out specific to this. You get better individual outcomes. That's from both sides. You have improved resolution time and rates. Case takes less time. You have a greater rate of conclusion. It takes less time. More lasting rapport with both clients and your opponents, and a more personally positive experience. So we have reason to believe that it would be a good thing if we were highly emotional intelligent when we're doing negotiations or mediations. Next slide. So we're going to talk about some of the emotional currents that are likely to be going on during negotiation. It's very important, which is where that perception piece is to understand what your own biases and vulnerabilities and feelings about what's going on are. Your feelings about success, money, justice, the individual parties, your opponents. Those feelings can cloud your judgment. They can change your judgment in ways you don't want them to. So one thing that we've found in research, which is we will return to several times, is that naming an emotion out loud can quiet the amygdala, can reduce the amount of activity so you get a little clearer view of what's going on. Naming those emotions, which may not be a natural thing to do, but it looks like you're very angry, or tell me why you're so upset about this. That just talking about it, naming it, helps reduce that agitation in the amygdala. In Getting to Yes, the authors suggested that the party's emotions from the start should be made explicit, and they should be acknowledged as legitimate. They even say you should encourage letting the other side let off steam, but not reacting negatively to that. Okay, so next, what's the most common emotion that negotiators, experienced negotiators, feel during a negotiation? What would that be? That's anxiety. So yes, doesn't that make sense? We feel anxious, will you be able to get an agreement? It will be what your client wants, one everyone's happy with. What kind of emotional experience is it going to be to get there? But this is the deal about anxiety. We know that anxiety restricts our perceptions, makes us defensive, and closes us down. And that defensiveness is usually read across the table as deception or hostility, which increases their defensiveness and in turn escalates these tensions. Specifically, anxious negotiators set lower expectations, make lower first offers, respond more quickly to offers, which in this case is not good, exit negotiations earlier, and attain worse individual outcomes. These are behaviors that are not necessarily due to other negative emotions, but that anxiety, you're so uncomfortable with what's going on, with your fears, that you're essentially rushing through the negotiation. So an important thing is, can you enter that negotiation in a more placid state? Next. What about negative emotions? Well, there's a lot of negative emotions that can occur during a negotiation. There's anger, fear, frustration. All of these cloud your judgment. They escalate conflict, they reduce the trust, they harm relationships, and they can lead to counterproductive actions from the other side. Anger, for example, has some benefit. It can energize you, can focus you, but it's also self-reinforcing, and it tends to produce a more punitive result than you would otherwise. So anger is something you have to be careful of. There's been studies that say high power negotiators can benefit from expressing anger, but the low power negotiators usually do not, because their high power counterparts could possibly retaliate. So anger is one of those things. Depression is another slightly depressed mood, which again, lawyers have a tendency towards, although not in negotiation. It can make you less gullible, can make you pay more attention, but, and remember details, good things, but you can't do that on a prolonged basis, because if you do it on a prolonged basis, you can't assess the situation. You can't, you're not in as good, you're in that less than optimal space. Let's go to the next slide. Nope. Whoops, go back one. There we go. Positive emotions. Positive emotions. So positive emotions, is it okay to come in with those? These are good humor, optimism, compassion, positivity, appreciation. Those are all sort of positive feelings to go into a negotiation with. We get better problem solving, more creativity and collaboration. It's been clearly demonstrated it's better to start a negotiation in a good mood and then turn more negative than to start out in a negative one and turn more good mood. It's been determined, a study, that you can realize all the monetary benefits of an angry negotiating style if you start out in a good mood. But at the same time, you'll keep your negotiating partner from disliking you to the point that they might want to retaliate. So this positive emotion is worth considering in your negotiations, employing that. And remember that positive emotions could also be contagious, so that you get a more positive feelings from the other participants in your negotiation. I'd like to point out that this doesn't mean you're nice. That's the thing. You don't have to be nice. You can be firm. You can exact standards and stuff. It's just being positive. And let me share another presentation I often do, which is on leadership. And particularly for lawyers, what's interesting is that the two most important traits of the most influential leaders are, surprisingly, first, warmth, second, competence. So warmth, does that mean, again, are you the squishy, soft leader? No, it just means that when you express your opinion, it can be firmly, can be unreservedly, without reservations, let's do it that way, as long as it's warm. And warmth is a style. Warmth is an emotional, carries emotions. Daniel Goleman did a lot of work in this area when he found that you can deliver essentially a very negative message with warmth, and the person receiving that message believes that was a positive experience. He used firing people. You know, you can say you're fired, negative experience, negative delivery. Or you can say, we, in a very warm or positive way, you know, sorry to see you leave. It hasn't worked out. We appreciate your contribution. We hope you'll keep in touch. I mean, though people will look, they still got fired, but they'll look back at that as being a positive experience, which particularly for lawyers, you want to keep in contact with those people, because who knows what general counsel they're going to become. So learning to use positive emotions is very important. One of those is not confidence or overconfidence. So I want to talk about that a little bit. Randall Kaiser with Decision Set, I don't know if anybody, he's written several books. He looked at a lot of litigation matters and came up with some very interesting stats on lawyers and their assessment of cases, their predictions of cases. and one in which he reviewed 15,000 actual litigation matters. In 60% of the cases, the settlement the lawyer refused was more lucrative for their clients than what they ended up getting at trial. That's pretty discouraging, 60%. So I see we're getting close to time. I'm going to quickly say also on the negative emotions that positive lawyers are high in pessimism. That's their primary trait. So it's very important to try to embrace these positive emotions. Can we go to the next slide?
Rhonda, when you're
Okay.
ready, I've got some final questions for you. So I don't know, you can tell me, but we're coming 5 minutes.
I know we're coming close. Okay,
Yeah.
let's go ahead and hit the slide again. Let me just put this up.
Okay.
These are some things you can do to raise your own personal emotional intelligence, particularly the perception piece. Counting to 10, letting those neurochemicals wash out so we can get back to your prefrontal lobe. I like watching muted TVs and movies to see if you can follow the plot. Check in occasionally. Can you see what's going on? Find somebody who can help you analyze the situation. Just be curious, how are you feeling? Did I get this right? You look such and such. Track and name emotions. Expanding our vocabulary is something we need to do because you can't deal with an emotion you can't name. Mindfulness, we could talk a lot about that. Using a third person perspective, trying to change your body to change how you're feeling emotionally, and using positivity. So we could talk about all of those things a lot of time, but let's go on, Scott, to any other
I was
questions.
going to say, I think we all need to get your book to answer all these great questions that you're bringing up. With the few minutes we have left, let me. This is a really interesting question. What level of impact do you think that family of origin, moral injury experiences, or cultural traits have on emotions when coming to the table with regard to emotional intelligence? Those are really interesting factors.
Well, sort of what I talked about, your amygdala stores those early family experiences, and there may be triggers that you don't even know about. A lot of those are unconscious, as they would be with in utero and past generational traumas. So they definitely have an impact. What was the other family?
It was family of origin, moral injury experiences, or cultural traits.
Oral injury, I don't think there's been much done on that. But culture, we do know there's been quite a bit done on geographic, are there any differences in what constitutes emotional intelligence? The scoring holds true geographically. There are some cultural differences, like some instances, standing too close is considered more of an assault than. So there are some cultural different, but those perception, empathy, understand, those four pieces are pretty constant across races and cultures.
All right, and then our last question, I kind of love this one. Is emotional intelligence more important and useful to incorporate today versus 30 years ago, because the younger generations today are more emotional than older generations?
Well, that's interesting. They're more emotional, but they're less emotionally intelligent. Unfortunately, there was a trend for quite a while for emotional intelligence across the country to go up. Now it's going down. A couple of reasons. One, COVID, that they were kept from experiencing those reactions and those interactions that would build their emotional intelligence. Also, frankly, there's so much use of pharmaceuticals now that dull emotions and dull your understanding of emotions. That's been a real problem. So yes, I guess we do need a more emotional intelligence. I also believe, in a quick aside, that in the age of AI, emotional intelligence is what's going to be what distinguishes you and makes you valuable as a legal counselor.
That I absolutely agree on. We don't want to be replaced because we're the ones providing the emotional intelligence to the equation.
Right.
Boy, Rhonda, thank you so much. That was really interesting. I can't wait to read your book. And appreciate it. I know you put out there the discount code for us to get the book if we're interested. And thank you for your time. really interesting for us as neutrals and mediators to hear from your perspective on emotional intelligence. So thank you so much for joining us.
Thank you, and thank you, your staff, for saving me from my technology.
Terrific. All right, we'll talk soon. Thank you.
Okay, bye.
And last but not least, our final speaker for the day, John, I'm so happy that you were able to fit us into your schedule, and so appreciate you joining us. I'm gonna do a little short introduction. John especially told me, don't read the long one, read the short one. So I want folks to know about you and the materials that you've provided. You're the Isidore Loeb Professor Emeritus at the University of Missouri School of Law and former director of the LLM program in dispute resolution, earning your JD from Hastings College of Law, PhD in sociology from the University of Wisconsin in Madison, and began practicing law and mediation in California in 1980. The American Bar Association have published your books that folks can have access to. He developed the Real Practice Systems Project to help practitioners, scholars, and students better understand the realities of dispute resolution practice. Received many awards for your scholarship, including the American Bar Association Section of Dispute Resolutions Award for Outstanding Scholarly Work. And you write for indisputably.org is your blog. I want to hear more about that. And your website, law.missouri.edu/Landy. And I'm sure folks will be reaching out to you after your program. So John, you've got the Anchor Project presentation today. So presentation today. So go ahead and finish us off, and we'll leave it to you now.
Thank you very much, Scott. Thanks for all of you to come. I've been watching Rhonda's presentation, and this is a good segue because she just ended by talking about artificial intelligence, which is the focus of what I'm going to be talking about today. So I am going to try and share my screen, and hopefully I'll be more successful than Rhonda. And is that working? Can you all see that?
Yes, if you'll just put it into presentation mode. Yep, that's perfect.
Excellent. Okay. So this is about how you can use AI to help mediators, lawyers, and parties. And again, thinking about Rhonda's presentation, I think part of it is that it can help you understand emotions in addition to a wide range of other things. So here's the plan for today. Again, appreciate your inviting me. I'm going to be talking about this real practice system theory that Scott mentioned that I've developed. And I'll be giving you a demonstration of AI. And I'm going to be going through this pretty fast because the best part is the demonstration. I'm going to have you volunteer questions from your experience, hopefully real cases without identifying specific names or other personally identifying information, and see what an AI tool will do with it. And I'm going to show you some of the things as we go along. I'm going to see if Scott or Lane can upload my PowerPoint in the chat so I don't get distracted. You'll see that some of the later slides have my links to various things that I've written, including my email if you want to get in touch, the Indisputably blog, and other things. So if you're interested, you can follow up there. Okay, so let me tell you a little bit about me, picking up a little bit on what Scott said. Got my law degree in 1980. In the mid-1980s, I had a law and mediation practice. I was very interested in sociology of law, particularly sociology of dispute resolution, and I got my PhD in sociology. From 2000 to 2015, I was a full-time faculty member at Missouri. Since I retired in 2015, I've been writing and particularly developing this real practice system theory. My friends tease me that I'm the busiest retired person they know. I've been using AI a lot, and that has increased the quantity and quality of my production of materials. So how can it help mediators and lawyers? And of course, I'm assuming that most of the folks on this call are neutrals, and many of you are working with lawyers. And one of the things that I'm suggesting is that you can improve a mediation process not only by your use, assuming that you're mediators, but by encouraging lawyers to use it and actually encouraging lawyers to use it with their clients. So how can it help? One of the things that the studies show is that users find that it helps them work faster. It can help them develop better ideas. I've given this presentation a lot around the country, courtesy of Zoom. And one of the things that I have found is that I've had people enter their real cases that they've had problems, and the output comes out with things that they wish they had thought of in the moment. And one of the things that is really cool about AI is that it produces responses so quickly that you can actually use it in real time during mediation sessions. And of course, it's also especially helpful for preparation before mediation sessions, as well as reflection afterwards. So you can prepare more thoroughly and efficiently. You can make good decisions and particularly help parties make good decisions, which is really the main value underlying this real practice system theory that I'm going to talk about. That can help clients develop trust and confidence. You can access specialized legal and mediation knowledge with various AI tools. Afterwards, you can debrief challenging cases and improve techniques. As I said, I've had mediators enter facts of cases that they've done and found that it suggests ideas that they wish they had thought of in the moment. And of course, they can help them work more efficiently. So how can it help parties? They can learn about mediation generally. They can prepare for mediation sessions, which again, I'm a big believer in preparation as helping the process. They can plan to collaborate with their lawyers. Research shows that lawyers and clients are like, people from Mars and Venus, that they have a hard time communicating with each other. And so they could actually use AI tools. So a lawyer could say, here's a client and I'm having a problem communicating with them, or vice versa, a client saying, where's my lawyer coming from? It can help them consider others' perspectives, which is a critical issue or a critical need in a mediation. People often have their own self-interested perspective and they have a hard time understanding the other's perspective. And that's one of the things that mediators try and do, is that help them understand others' perspectives. AI tools can help them do that. You can brainstorm in real time during mediation sessions, develop negotiation and mediation strategies, and analyze possible agreements. So it can do a lot of things, and we're going to do some demonstrations to show you. Tips for using AI well. One of the things is that, since ChatGPT came on the scene in November 2022, people have been starting to use it, using it increasingly, and aware of problems with it, although not everyone is. And of course, we read our articles in the news about lawyers who file papers with hallucinated citations and they get sanctioned. And indeed, some courts have standing rules about checking any AI generated output before filing it. So that there can not only be hallucinations, but it's not perfect. It may not give you the output you're looking for. So part of it is you need to use it. The humans need to be in control, not just take the output and assume that that's going to be the right answer. Often there isn't a right answer. Part of it is asking clear, specific questions. And a really important part is treating it as a dialogue, not just taking the first response. I think a lot of people assume that you ask a question and then you get a response and that's the right answer and that's where you leave it. Well, that's just the first part. To really get the benefit of AI, you really need to have a conversation, a back and forth, to probe and to challenge, in a sense, do a cross-examination of the AI responses to check and see if they're right or if they might do it better. And of course, given the issues about hallucinations, anything that you want to rely on, you should verify the accuracy and usefulness. A lot of the tools these days are providing links so that you can directly and quickly go to sources to check. And sometimes my experience is often they're right, but not necessarily. Of course, you should also protect confidentiality, an important ethical requirement for mediators and lawyers. And that's actually relatively simple to do. First thing is don't put in any names or other personally identifying information. So if you're just typing in or dictating a prompt, you can avoid doing that. And, practitioners do this all the time. You talk with colleagues about cases and you don't tell the names of the parties or enough information that they could identify them. If you're uploading documents, again, you need to be careful. And there are settings that you can set on many AI tools. Some of them do this by default, where they don't use the information you provide to train their model, so that basically it just resides in your version of it. Although, as I understand it, and I'm not an expert on this, even if you don't do that, it's the way these tools are designed. It breaks your prompts into these small chunks called tokens, which are hard to reassemble. So even if you didn't protect confidentiality, probably the information couldn't be reassembled, but it's just better and wiser not to put any names or personally identifying information in, and then you just don't have to worry about that at all. Okay, so how do you write a good prompt? You want to start by identifying your role. I'm a lawyer, I'm a mediator, I'm a party. I write a lot for legal educators. I'm a faculty member, I'm a student. And then state your task. I need help. I'm preparing for a mediation. I'm in the middle of a mediation and it's going sideways because X, Y, and Z. I need your help. Provide the context. So here I'm in the middle of this mediation, or this mediation is about a commercial contract. Describe the type of output. Oh, I'd like you to come up with some suggested options for me to suggest, or for the parties to consider. I do a lot of writing, and of course a lot of lawyers do too, and some mediators, and you may have a draft an agreement, or draft a term sheet, or all sorts of things. Whatever it is that you want, tell it what you want, and then add whatever details you need, and you can include your jurisdiction, goals, or techniques that you wanted to focus on. So that's your basic formula for writing effective prompts. So here are some sample prompts, and again, these are just condensed prompts, but these will illustrate the kinds of things that you might ask an AI tool to do. So what should I discuss with parties or attorneys to prepare for a mediation session? How can I get parties to consider the other side's perspective? Again, one of the basic things that mediators need to do in order to help people move forward in the process. How can I get an attorney to be more reasonable? Well, I suppose maybe this is theoretical because all mediators are reasonable, but in case you happen to have the one attorney who is not reasonable, you might ask that question. What are options in addition to lump sum payments? Again, a lot of mediation these days focuses only on lump sum payments, and that's okay. A lot of times parties are interested in additional things, sometimes payments over time, apologies, all sorts of other things, so that you can ask it to come up with those things which people often don't think about. Help me figure out what went wrong in this case. This is a useful prompt if you're going to be developing your skills, so you can learn from each case, and it can do this in a more systematic way than people might do on their own. So here's some sample prompts for lawyers. Help me explain to my client the intangible costs of litigating a sexual harassment case. So part of this is, again, clients may not have a good sense of what's likely to happen if they proceed in litigation, and that can be a challenging thing for lawyers to explain to clients. Help me write a first draft of a mediation memo. I hear mediators complain all the time about how the mediation memos they get from lawyers stink, and that if they could, use AI to write better, more effective mediation memos, that would be great. help me develop a bottom line considering the expected court outcome, future litigation expenses, and my client's intangible interests. This comes out of a book that I wrote for the ABA with two wonderful co-authors, Michaela Keat and Heather Haven, and it's called Litigation Interest and Risk Assessment, Help Your Clients Make Better Decisions. And what it focuses on is all three of these elements. People often focus only on the expected court outcome. And again, I'm assuming that many of you have, that's the focus of your mediations, so the plaintiff says, well, if we go to trial, I'm going to get a lot of money. And the defendant says, if you go to trial, you're going to get little amount of money. Part of what this can do is to help people think about what might happen if they go to trial, which of course very few cases do. They also should be thinking about their litigation expenses, which sometimes are considered, and then the client's intangible interests, so reputation, relationships, stress, anxiety, opportunity costs, a whole bunch of them that are listed in this book, as well as a document with checklists that I'll show you in a bit. So if you combine all those things, you can come up with a bottom line for parties, for example, plaintiffs that think the least that they would accept or the most that a defendant would pay. So you can use AI to do that. How can I encourage the other attorney to be more reasonable? Again, that's theoretical, since we know all attorneys are extremely reasonable. And for parties, here's some sample prompts. What should I know before attending a mediation session? Help me work with my lawyer who's focused only on money. I want an apology too. Again, a common tension. How should I respond to the other side's offer? Should I accept the other side's offer or keep litigating? Okay, so now I'm going to shift gears. I've been talking about AI generally. Now I'm going to talk about this real practice system theory that I have developed in response to dissatisfaction with traditional mediation theories like facilitative and evaluative mediation. I've written a lot about that. Take my word for it. I think that they are misleading and incomplete, and this real practice system theory is much more complete and much more practical and helpful. I'm going to focus here on the mediation practice systems, but it can be applied in lots of other contexts. So mediators develop systems through regular practice, and I'm assuming that most of the folks on this call have been mediating for a while, and if so, you have a practice system, whether you know it or not, and that is that you take certain actions before, during, and after mediation sessions. Some of them are conscious and many of them are unconscious. They're just habits that you develop over time and you don't even think about it. And that's appropriate. I mean, you have to think about everything all the time. You couldn't get anything done. And this kind of builds on some of the work that Rhonda was talking about in the Thinking Fast and Slow of how our brains work. Some of it's conscious. And of course, we're more focused on that. And factors that affect your systems will include a whole range of things, including your personal history, the training you went through, the kind of cases you've had, your family history, lots of different things, your values, motivations, knowledge, and skills, the kind of cases and parties you deal with, and the behavior patterns you have. And so if you recognize that you have a practice system, yours is unique, and that if you and someone else, someone you know, someone who you respect highly, were to mediate the exact same case, you would do it differently because of all of these factors. And so part of what mediators do is to design your systems to include certain routine procedures, as well as develop strategies for recurring challenges. So if you are doing personal injury cases or family cases or whatever, you often will recognize categories of situations, behavior patterns, and then you'll develop strategies for dealing with it. So, we have this kind of problem where someone is not looking into, not aware of their the risks and what would happen if they went to trial. So you develop strategies for dealing with things like that. So this slide is a graphic representation of what I just talked about, and I think in some ways may help. You can see that there are 4 rows which talk about different stages of the process. People often think about only that 3rd row, the mediation session. And again, as I've described, I think that the process beforehand is really important. Not everybody has, not all the parties are represented by attorneys. Not everybody has a careful process beforehand. So not all of the cells in this graphic occur in every case, but this is a more complete representation of it. And in a good case where parties are represented by lawyers, then the lawyers should, in this light blue cell, they should do a good job of lawyering, which is learning the facts, evaluating the case, doing legal research if they need to, advising the clients, and then of course retaining a mediator, which is a really important element that actually many of the traditional theories this is one of the many things that they don't deal with. Even if you're ordered to mediate, many courts will give the lawyers the power to choose a mediator, and obviously that can make a huge difference. And so that's an important piece of it. And the parties come in and have their variety of emotions, again, that Rhonda talked about, and that part of what lawyers should be doing is conducting what I call client school to help them understand what the situation is and what their options are. And then if going to the 2nd row, the preparation for mediation session. So assuming that there is a mediation session, ideally, the mediators would coordinate this. That's the yellow cell. And so they would talk with, perhaps have conversations with the attorneys ahead of time, get mediation memos or other documents, and the attorneys would coordinate with the mediators and also help their clients prepare for the mediation session. And then you get to the mediation session itself, which often is the focus. And this is where the mediators in the green cell take the lead and are managing the process. And the idea is to focus on the orange cell to help parties make the best possible decisions, and if possible, reach an agreement that they feel satisfies their interests. And then the 4th row deals with what happens after a mediation session, and there may be follow-up depending on whether the parties reach agreement or not, and the implementation of it. So what this does is it helps people think about this wide range of activities involved in mediation for mediators as well as attorneys and parties. And all of these things at different times, people might use AI to focus on. So here's a checklist that comes out of this Lyra book that I mentioned, as well as this checklist document. So you can think about the things that mediators do or their staff conduct intake, possibly, not all these things, discuss the dispute and participants, arrange to receive documents, and then during the sessions to initiate the session, learn the history of the dispute and the parties' interests, help evaluate possible court outcomes, help address emotional challenges. I really appreciated Rhonda's presentation and the importance of that. And unfortunately, I think, that her reference to if I wanted to be a lawyer or if I wanted to deal with emotions, I would never gone to law school is unfortunately the way a lot of lawyers and law-trained mediators feel. And for the reasons that she describes in great detail and what many of us understand intuitively, emotions are really important. And if you focus only on the numbers and only on the settlement, then you may miss important pieces and you may not reach agreements that would satisfy the parties because you haven't focused on the emotions. And of course, obviously, the goal is to help resolve disagreements if possible. And after sessions, do the follow-up and then reflect on cases and lessons learned so that you can continue to improve your skills in your practice. So here are some of the resources. I've written a ton. These two that I've highlighted, I think, are particularly valuable. These are talking about how to write good AI prompts. And this first one is a basic one. And then the second one, the art of AI prompting, goes into more depth. And if you're interested in using AI, I would definitely recommend that. Then these next two deal with these checklists that I talked about. In some ways, it grows out of or is related to this LIRA book, the Litigation Interest and Risk Assessment book that I talked about. And these are 15-page documents that go through long checklists of things that mediators and attorneys might do in general for their practice, and then before, during, and after mediation sessions. And again, very, very detailed. This next article, how can you turn adversarial attorneys into quasi-mediators? Again, I was joking about attorneys not being or all being reasonable. Unfortunately, that's not always the case. And there are some techniques to help them become more reasonable. When I say quasi-mediators, obviously they're not being neutral, they're representing their clients, but help them reach agreements or try and reach agreements that are in their clients' interests. And there's some techniques you can do. And then this last one is a description of the LIRA book that I mentioned. And then if you're interested, you can see more of my resources. I've got a website, an SSRN page that collects all sorts of publications. Then this Indisputably blog where I blog, and then I've created my own AI tool, and you can see that. And then here's my email address if you want to get in touch with me. Okay, now that I have stopped or that I've finished giving my presentation, we're going to shift gears to take a look at how you can use mediation. So I'm going to read you two fact patterns, and then we're going to switch gears to have you enter them. And so again, I want you to be thinking about facts that you might enter. So I'm going to just read this to you, and then after this, I'm going to shift gears, and we're going to share the screen and take a look at how ChatGPT would handle it. So the first case is, I'm a mediator preparing to mediate a dispute between two manufacturing companies. The plaintiff claims the defendant misappropriated proprietary technology and seeks $2 million in damages. The defendant says the technology was developed independently. For the mediation session, what should I ask the lawyers to understand the parties' priorities, litigation, risks, and emotions? Second one, this is from the perspective of a lawyer. I'm a plaintiff's lawyer representing a client injured in a car accident. She has significant medical bills, lost income, and ongoing pain. The defense admits fault but disputes the extent of the injuries and future losses. They offered $200,000, which is far too low. I want strategies to move the defense toward a reasonable offer and ways to prepare my client for a realistic risk assessment and mediation. So I'm going to have you, we're going to do it together. I'm going to have you suggest from real cases if possible without identifying information, possibly suggesting queries from the party's perspective. And then you can suggest questions other than my examples. So with that, I'm going to stop the share, and I'm going to start it again so that we can, all right. So I'm just going to, one of the cool things is that you can dictate into, and can you see the share screen of the ChatGPT? I'm assuming you can. Is that right, Scott?
Yes. Yeah, we can see it.
Great. All right. So you can dictate it. I didn't realize that until recently. I keep on learning about this. I've been focusing on this and using AI every day since the beginning of February, and I keep on learning things, one of which is that you can dictate and not just type things in. So I'm going to read that first problem and see what it comes up with. And one of the things is that this is based on a probabilistic approach, so you can ask the same question to the same tool and it will come up with different, usually pretty similar answers. So I'm going to read the first one and see what it says. I'm a mediator preparing to mediate a dispute between two manufacturing companies. The plaintiff claims the defendant misappropriated proprietary technology and seeks $2 million in damages. The defendant says the technology was developed independently. Before the mediation session, what should I ask the lawyers to understand the parties' priorities, litigation risks, and emotions? Okay, now one of the things is it does a really pretty good job of voice recognition and transcription. So here this is, and you click the up arrow and we'll see what it does. Great. And one of the things is that it's always very positive. You're thinking like a serious mediator. Before a session like this, you want to gather 3 categories of information: facts and positions, interests and perceptions, and emotional and relational dynamics. So find out about the case background and core issues. How would you summarize the core dispute in plain English? What are the main factual disagreements, and so on? Look at the priorities and business interests. Shift the conversation away from positions, the $2 million versus we owe nothing, toward underlying business needs. Beyond the money, what's most important to you? These are what we call in this Lyra book the intangible interests, and then talk about litigation and risks and realities. Push gently but clearly on how each side perceives risks. Most lawyers overestimate their control and underestimate certainty. Again, Rhonda cited this study, which has been replicated, about how in an unfortunately high percentage of cases that go to trial, parties have rejected better offers, better results in negotiation than they get at trial. This is a horrible, horrible outcome. And one of the things that mediators can do is to help parties and attorneys develop more realistic expectations about what would happen if they go to court. And then here it is, you're talking about client emotions and internal dynamics, talk about the negotiation process and practicalities. Bottom line, you're not just collecting facts, you're mapping each party's negotiation system, how they think, feel, and decide under actual pressure, If you want, I can help you draft a pre-mediation questionnaire or email template. One of the things is that I use ChatGPT because I paid for it. You can use free versions of these AI tools, but generally they are, you get better quality service if you have paid versions. So then I'm going to read the second one, and I realized I should stop for questions, and then we will go to having people do their own prompts. So here I'm going to read the second one. I'm a plaintiff's lawyer representing a client injured in a car accident. She has significant medical bills, lost income, and ongoing pain. The defense admits fault, but disputes the extent of the injuries and future losses. They offered $200,000, which is far too low. I want strategies to move the defense toward a reasonable offer and ways to prepare my client for realistic risk assessment at mediation. All right, so again, we're going to have pretty fast transcription. See what it says. Great, you're thinking like a serious advocate. Break this into 2 parts: influencing the defense to move meaningfully and preparing your client to make sound reality-based decisions. Moving the defense towards a reasonable offer, undermine their comfort zone, give them a path to movement, use the mediator effectively. Again, I'm skipping through the detail. You can read it, but you get the sense of it. Again, I want to have more time for you all to do your prompts. And then preparing your client, educate your client early and honestly, run scenario planning. So this is like doing a decision tree, address the client's emotional readiness, align the expectations before you walk in so that they're prepared, and give them the blunt truth. So these are illustrations of what you can do with AI in a mediation context. So Scott, let me ask you, are there any questions that people have entered into the chat?
Yes, there are. I've got a bunch of questions going to the issue of how you would notify your client that you're using AI, and effectively, I guess the question is, one about notice and two about the need for consent. So talk about that responsibility and the ethical aspects of letting them know about your reliance on AI.
Sure. Well, one of the things I should just say at the outset is the ABA last year in 2024 issued formal ethics opinion 512, which talks about lawyers' ethical obligations related to AI. And basically it says it applies, you know, you don't need a new rule because the existing rules cover it. And in terms of consent, I guess I'm not sure, and I don't know that there's a right answer to this. My impression is that you don't necessarily need to disclose your use of AI unless it seems like that would affect people's decisions. So, you know, if you're using Westlaw or if you're using Google or all sorts of other tools, do you have to disclose that to parties? I'm not sure that you do. You know, if there was a situation where it might affect the client's judgment, I assume that you would, but in general, my assumption is that you would not.
All right, here's another one, very interesting. How does AI replicate the emotion of the case? And specifically, does the response that you just received from AI change based upon how you speak to the AI generator? Meaning, if your questions, you were pretty flatline when you were, you know, dictating. Would it change if you put emotion in your voice asking the question? I'm just curious about that.
A really good question. I don't know the answer to that one. Again, I use AI all the time, and of course, the questioner was right that I was reading this pretty flatline because I was trying to move quickly. When I use it with my own tool, and I've developed this relationship with my tool, I am very emphatic. The short answer is I don't think that makes a difference. I think that it just responds to the text, and maybe it would do a little different voice recognition, but I don't think that it would. And I think part of the question also relates to the emotions in a case. And part of that would be explicitly, well, one is you could see that some of these responses themselves deal with emotions, address emotional readiness. So one of the things you could do is to say, acknowledge your feelings. So I'm just going to follow up with that. So you said I should acknowledge my client's feelings. Can you tell me more about how I could do that? And this is an example of a follow-up question, and also how you can get into the emotions. So let's see what it says. Excellent question. One of these days it'll tell you you've got a dumb question, but I haven't seen that yet. Understand what acknowledgement really means. Talk about language that works. Again, so much of this follows off of what Rhonda was talking about. Think about body language, bridge to realism, why this works. So basically, in terms of dealing with emotions, you can ask it and it will come up with responses, and you may or may not agree with them. Sometimes people say, well, I like most of it, but I don't like, you know, some of it. Well, fine. Take the stuff you like and ignore the stuff you don't, or push back on it. So hopefully that answered that question. What's the next one, Scott?
Well, I just the tail part of that is on the emotion from AI. It's either that we don't believe what it's saying because we don't want to believe that AI has emotion. So I guess the issue is, I think a lot of us are afraid that if AI really had emotion, it would really truly take the place of all of us if it had the intelligence and the emotion.
Based on my 9 months experience of AI to date, I'm not worried about that now or in the immediate future in terms of it taking control. I will tell you that I mean, in some ways, it's very easy to anthropomorphize AI, and particularly when it comes back with this, in a sense, human sounding responses, but it's still a machine. One of the things is, I've trained my tool based on my publications. And when I write, I have a particular document that describes my approach to writing. And so this may sound weird, but I will joke with back and forth with my tool, and I bet we could joke with this tool. But it's a simulation of emotion. Again, in terms of having AI tools overtake us, that could happen at some point, but it's not happening now, I don't think, at least in terms of the generally available tools. And they do some decent work, but they also have lots of problems. And so I guess I'm not worried about that in the short term.
Okay, well, maybe at the end of the program, you can ask them to tell a lawyer joke and see what we come up with, but I'll wait on that one. Here's another question. You talked about your real practice system, and that each of us come into doing our mediations based upon our own background and experience and perspectives. How do we know if we're doing it right or doing it wrong? What, other than maybe ultimately whether the case settles or not settles, how do we know whether our real practice systems are good?
A great question. And I mean, in some ways, you have your own metrics about what good is. So for many mediators, it's a settlement rate. For many mediators, there are other aspects of it. So it may be, referral percentage. So, do attorneys come back to you and say, oh yeah, I want you to do it again? Maybe an emotional reaction of, how did it feel during and after the mediation process? So there's, this system approach doesn't say that there's one right way of doing it. It says you have to think about your own system. And one of the things that you can do is to help develop it. And, my tool is specifically designed, it's based on this real practice system theory, and you can actually have conversations with it to identify what your theory is and your values and your goals, and then develop a profile. One of the articles that I'm planning to write is actually about how mediators or other practitioners can develop their own theories. All right, Scott, I want to shift gears. I'd love to answer these questions, and I'd love to talk forever, but I want to have at least a little bit of time for people to enter their own prompts. So I'm wondering if there's anybody who would like to dictate a prompt and see what it comes up with. Particularly, it would be great if it came out of your own practice experience. Can someone volunteer, maybe by raising your hand? Or
Well, they're not going to be able to raise their hand. We have 200 people on the screen here. So if they have a prompt, they can put it in the chat. And while we're waiting to ask to see if anybody puts any prompts in the chat for you to put in, let me ask one more question that's come
Sure.
up about AI, and it interacts with your real practice system. Will the use of AI impact the cultural or implicit bias that mediators bring to their mediations? So would it take out that potential, would use of AI take out that potential argument that mediators or neutrals come to their matters with their own bias?
I doubt it. For one thing, the tools have their own biases, their underlying biases that the developers train, and then people enter their own prompts, and so they decide what prompts to enter, and then they decide what to make of the responses. So I don't think that would happen. I don't think it would take it out. One of the things for my tool, which is based on this real practice system, is that it has some very explicit values that it's based on, primarily promoting good client decision making and a variety of other things. I wrote one of my pieces is RPS Coach, my tool, is biased and proud of it. And so it is trained on certain biases. And so if you use it, then you will get responses that are related to that. But it's not going to filter out biases. And so in some ways, it may help people identify their own biases if they're interested in looking at that.
Well, I don't have any takers for prompts. You've
Okay.
got
well,
an intimidated audience here, so you may
Well,
have,
it's-
oh, wait, let's see. Here's a question. Okay. Well, I don't know if this is a prompt, but maybe you could put it into the prompt to figure out how to answer this.
Well, actually, what we can do is
Yeah.
I'm going to have you read it, and I'll just click on the dictate. So when you're ready, I will click on the dictate, and this should work.
Okay. So the question is, how do I determine how much a client's pain and suffering is worth?
Okay. Now, that's a very general question, and let's just see what it comes up with. That's the right and brutally honest question. There's no formula that truly captures what pain and suffering are worth, but there are disciplined ways to anchor your valuation in evidence, precedent, or realism. Start with the concrete, economic damages. Look at comparative verdict and settlement data. Evaluate the human story variables. Use ratios as a sanity check. Avoid the 3 times special formula, but you can use them to check reasonableness. Look at typical settlement ratios, not verdicts, which I have this degree in sociology that I mentioned, and one of the things that is important to understand, and of course people have an intuitive understanding of this, is that that people look at the trial outcomes, but we all know that particularly in the federal courts, but even in the state courts, you have very low trial rates. And the cases that go to trial are almost by definition outliers. They're weirdos. They're cases where people can't reach agreement. And really the better reference would be cases that are settled. And of course, there are some databases where you can find out about it, but one of the problems is that most of the settlements are confidential. So in some ways, if you're going to have a standard to compare it with, it would be great to have a settlement database. In Illinois, there was a magistrate judge who was developing a database for his settlement conferences, and he would use that to help parties, but I don't know. I mean, and there are databases, and people on the call may be familiar with them, where you can look up settlements. So anyway.
Okay. I have another
ahead.
one for you. I'll dictate in.
Okay.
Because this other one was very interesting. I have a mediation with a personal injury attorney who has clearly not prepared their client for the process or a realistic settlement value. How can I best handle this?
That is a great question, because I'm sure that happens all the time. This is great to have them type it into the chat and have you dictate. Classic and tough mediator's dilemma. You can't fix bad lawyering, but you can manage the consequences and still help parties reach reality. Here's how seasoned mediators handle an unprepared plaintiff and attorney who's lost control of expectations. First, recognize what's going on. Set the stage in joint session or an early caucus. Use your mediator voice, calm, neutral, and authoritative. So much of this just follows on what Rhonda was saying, which I thought was a terrific presentation to lay down the ground rules of reality. And then one of the things that it often will do is it will give you a script, and you can, you can use the script as is. Often what I do is I'll take part of it and then tinker with it. So mediation is about informed decision-making. Sometimes the numbers today may seem surprising, but part of the process is to look at risk costs and what happens if this doesn't settle. Use the private caucus to gauge the client. Give the lawyer an off-ramp. You can't publicly expose the lawyer's lack of prep, but in private, give them cover to recalibrate their client. So you could say, I sense your client might not have a full picture of how insurers evaluate these cases. Would it help if I spent some time explaining how mediators and adjusters typically analyze value just to take some of the pressure off you? So, I mean, I guess I'd be interested, well, reality testing without alienating, keeping the defense engaged, using numbers strategically when all else fails, suggest a mediator's proposal, provide the blunt truth. I mean, as I look at the responses that we've seen today and the ones that I've done in past presentations, my sense is that these are standard mediation 101 ideas. The thing is that not everybody thinks of all of them and won't necessarily have some of the suggested language. So I think they're pretty good. I guess I'd be curious if people want to type into the chat, do these make sense to you? And to the extent that there are problematic or incomplete responses, could you imagine asking follow-up questions to get better responses? So that's my take. That's a great one. What else you got, Scott?
Well, yeah, I mean, and we're looking at the end here. It says, if you'd like, I can draft a short mediator script. One of the attendees literally asked before that came up, what would a script look like? So maybe you can ask them to prepare a short mediator script so we can see
Okay.
what it looks like.
Excellent. And one of the things is, again, these often will offer things, and a lot of times I just ignore them, but a lot of times I say, yeah. And so sometimes I will just type in the letter yes to, or Y to say yes. Yes. Excellent. Here's a ready-to-use Mediators Caucus script. Appreciate both of you taking the time to meet privately. Elicit feelings and expectations. Tell me what's most frustrating or important to you about this. What did you hope would happen today? I mean, again, these are mediation 101 scripts. If they vent, I hear how upsetting this has been. Again, going back to what Rhonda was talking about in terms of naming the emotions. Anyone in your shoes would feel that way. What we're doing here is seeing realistically what's realistically possible. Protect the lawyer and build alignment. Again, I think many mediators are conscious of that, both because it's going to make the process in a given case work better. And of course, the lawyers are the ones who are going to be hiring you in the future. Do some gentle but firm reality testing. Let's imagine you're in a jury box listening to this case. What do you think a jury might struggle with or question? This is one of the questions that we have in the checklist and in the Lyra book. If the jury believed your pain is real but didn't fully buy the future case estimate, what might you do to that? What might that do to your award? So here are more questions. Use numbers and hypotheticals to recalibrate, recenter on control and dignity. If the lawyer is floundering. So, I mean, again, there are just so many ideas here. And if you could do this in real time. You can see how fast this works. You can take, during a break, ask these questions. One of the things you can also do is when you are caucusing with the other side, you can suggest, hey, why don't you, lawyer and client, while I'm talking to the other side, why don't you use AI and brainstorm about some of these things and address some of these questions? And you can, in real time, I know a lot of people don't use joint sessions these days, but you could use it in a joint session, or you could use it with just the lawyers. I mean, there are lots of different ways you could do it. You could do this in a preparation phone call. So you could have a Zoom call like this, and then have a conversation with an attorney to prepare for the mediation session. So I could go on. What else you got, Scott?
Well, I have one more prompt for you before we wrap up. Okay, so.
And then we're going to ask the lawyer joke question.
Okay. Go ahead. I am a mediator. The plaintiff is a commercial photographer. The defendant is a company that admits it used the photographs. If the plaintiff wins, he gets his attorney's fees. How do I, as the mediator, get the parties to resolve the case before trial?
One of the things is that this transcription is really good. It cuts out the ums, the ahs, the pauses. So
Yes,
this
it did.
it really is very good. Excellent. This is just the kind of case where a mediator can make a real difference. Usually looks simple, but underneath there are layers of emotion, pride, and risk asymmetry. Understand the structure of leverage. The plaintiff's leverage. If he wins anything, the defense might not only owe damages, but all the attorney's fees, which can dwarf the damages. The defendant's leverage. If the plaintiff loses or recovers little, he may eat his own fees, and the plaintiff's lawyers can argue over claiming damages or lack of registration. Mutual risk, reframe the dispute early. Work each side's psychology. Use the information strategically. Use each lawyer privately. Offer process anchors. I mean, just a ton of ideas. You wouldn't use all of them, but if you use one and it worked, that would pay that would be worth the price of admission. So
That is something. Yep.
I need to I hadn't asked about lawyer jokes, so this is going to be interesting.
Make sure you ask for a clean lawyer joke.
Okay. Please tell me some of your favorite lawyer jokes and nothing obscene, please.
You might have broken AI with that question.
It could be. One of the things is that sometimes it's really slow. Okay, so sure, clean, classic, courtroom tested. The honest lawyer. What's the difference between a lawyer and a liar? The pronunciation. The devil made a deal with a lawyer. I'll make you rich, famous, and win every case for 20 years, but after that, your soul is mine. Lawyer replied, okay, but what's the catch? This classic one, shark joke, the lawyer's tombstone. Here lies an honest lawyer, somebody had underneath. Really? The lawyer finds a genie who grants him 3 wishes. The lawyer says, okay, I want $10 million, a private island, and to be surrounded by beautiful women. The genie says, done. By the way, just so you know, your partner already got the same thing, but doubled. Lawyer shouts, fine, but give me half as much heart disease. I don't think that one's funny.
All right. Yeah, I was gonna say we probably could have put in dad jokes, but I think this will do it. Here,
All
John,
right.
I'm gonna pop up with you to say my thank yous. But wow, I mean, what an interesting discussion about AI and the evolution of AI and what all of us do as neutrals and mediators. Really amazing.
It is amazing, and it just blows my mind what it does already. And one of the things that people should understand is that it's continuing to evolve, and people's ability to use it is evolving. And so it's going to, what AI is today is not what it is going to be tomorrow and a year from now. And it's almost certainly going to become more sophisticated. And clearly, more and more people are seeing that it's an essential part of their practice. And part of it is learning the skill of using it, which requires practice. You can't just, you could read my wonderful articles about how to design AI prompts, but you really need to apply them in real cases and see how it works and see how it works for you.
Really interesting. John, thank you so much for agreeing to participate in our International Conflict Resolution Day. You and the other speakers just made this such a fun morning. But John, thank you from all of us, and we'll see you soon.
All right, sounds good. Thank you all for coming. Bye-bye.
So Joyce and I have the opportunity to close out this program this morning. Joyce, goodness gracious, over 250 registrants and participants and 4 great programs. How are you doing?
I'm doing fine, and I want to congratulate you on putting together a very interesting program from a lot of different perspectives. And one thing that I'd love to take away from any CLE is inspiration, and all of these speakers were inspirational. Thank you.
Yeah, I agree with you. And so as we close, I just want to remind everybody that they have the continuing education or CLE credits available from the State Bar or the Georgia Office of Dispute Resolution. Reminder again about the program on November 11th with the GODR for you to participate in that. Stay attuned, as Joyce said, to other State Bar of Georgia programs, including our ADR section programs. If you're a State Bar member, but not a member of the ADR section, come join our group. We have really great programs and always looking for participants and involvement in our section. So again, I want to thank all of our speakers. Again, a shout out to Susan Guthrie for helping me with getting such incredible speakers for our program today. Another thank you to Lane Sozeby, who saved the day with the PowerPoint. So thank you, Lane. And that's all I have. Joyce, if you have anything else, but thank you everybody for participating and joining us today.
Thank you all for attending.